Pronouncement of judgment pertaining to item number 1.
The writ appeal is allowed to the extent indicated above. The respondent shall carry out and comply and pass necessary orders regarding regularization and absorption in service of the petitioner to entitle him to benefits of pension and other pensionary benefits for a period of 2 months from the date of receipt of a certified copy of this order. Writ appeal is disposed of.
Item 35.
So you are not pressing.
Not.
What is your name?
K. Uddin, my lord.
Heard Mr. K. Uddin, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner, Hafizur Rahman Bordhuya, had expired on
27/2/2022.
2022, and hence this criminal revision petition has become infectious. Stop. Considering the submissions made by learned counsel for the petitioner, this revision petition is disposed of on becoming infructuous.
My lord, I have filed a bail application, my lord. Yesterday, I pay, my lord, it may be taken on court, my lord. My lord, he is a long detention, my lord. He is arrested on 12/6. More than, my lord, about 90 days, my lord, he is behind the bar, my lord.
Fourth.
Your Lordship, I may be allowed to withdraw item 19 to business.
Item number? I'm not,
19.
be louder.
19.
Item number 19. What is your prayer? What is your prayer? Withdrawal. Okay. Heard Miss Otoli Kitts, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. Now also heard Miss M. Deka, learned counsel for NCB. Considering the submissions made by learned counsel for the petitioner, the prayer is allowed. This bail application is dismissed on withdrawal.
I beg to mention for listing of regular bill, lordship. I was filed, lordship, 20/8, but did not.
On 4th.
We have filed IL for correction, lordship. Maybe come the after 2 minutes.
Okay.
Okay.
Item 41 for withdrawal.
Heard Miss P. Bora, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Item 3.
May, please, Your Lordship. Lordship, this is a regular bail application, Lordship, intermediate quantity, Lordship.
Since when you are behind the bar?
Lordship, today, Lordship, 22 days.
Yes, very would be necessary. Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, call for the case diary. List this matter on
It's from page 4, Lordship.
15/9.
Obliged.
My pleasure, Lord. Regular bail petition, Lord. Petition under section 10 and 13 of the UAP Act. The case is required, Lord. But my basic contention would be, Lord, the violation of the provision 47.
Putul, mic to check. Karo. Yes,
Accusation under section 10 and 13 of UAP, Lord.
case diary would be required. Heard Mr. B. K. Gogoi, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, call for the case diary.
16.
Let this case be listed on 16th of September.
Obliged.
This is regular availability.
Heard Mr. What is your name?
Mundal.
A. Mandal, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case diary. And
Notice also.
issue notice to respondent number 2 in person to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on 18 September. List recording.
6.
My pleasure, Lord. Regular bail application, madam. Section 75.
CD would be required. Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, call for the case diary. Let this matter be listed on 17/9.
Highly open.
Item 7. Maybe. So it's a regular bail application and the charge sheet has been submitted, Your Lordship. The trial is pending before the landed court of Special Judge Mohega. LCR may be called for.
It's a POXO matter.
Yes, Your Lordship.
POXO.
Notices can copy.
Heard Mr. N. Islam,
Yes.
S. Alam, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Let the scanned copy of the trial court records be called for from the trial court. Let also notice be issued to the respondent number 2 in person to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on 23rd September. List accordingly.
Item 8.
My pleasure. Hey, my lord, CD may be called for, my lord. There are 44
Heard
days.
Mr. K. Borua, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Let the case diary be called for. List this matter
16, 17.
17/9.
Can it be, my lord, a little bit earlier, my lord, 44 days?
No, 17/9.
Obliged.
483 application, my lord. I'm behind the bar from 6/4/24. It is a case by Director of Revenue Intelligence, and interestingly, on the same day, charge sheet was filed against us. So, my lord, now 513 days. There are 3 accused persons were arrested on the same day, and 2 have been enlarged, but my case was rejected. That's why I'm before your lordship. Other 2 have been enlarged on the ground that 47 and 48 has also been complied with.
And
In my case also, it has not complied. But there is a judgment of our own High Court. That's a later judgment by my Lord Justice Pathak that I have enaged by Rashid Hawk versus State of Assam, Union of India, where, my Lord, it has been given that why my bail was not considered as mentioned. In view of this, I take your lordship to the impugned judgment.
no, let us call the scan copy.
Yes.
Will.
And trial has not yet started till today. Not
Heard,
charge was framed even.
heard Mr. A.C. Bishwas, learned counsel for the petitioner. Also heard Ms. M. Dekra, learned counsel for DRI. Let the scan copy of the trial court records as well as scan copy of the connected case diary be called for from the trial court. Let this case be listed again on 23rd September.
Highly obliged.
Item 10.
Wait, is your lordship. Lordship, this is an anticipatory bail application. Lordship has perused the case diary and granted interim bail to the co-accused lordship. After lordship will find on page 15. This is the case lordship probably remember 60,000 was taken by the from the informant by one Raju Ali lordship for the treatment of her mother lordship. And lordship granted bail to this Raju Ali, that is alias Sahajan Ahmed. He said he is a Sahajan Ahmed, that is on page 20 lordship. Allegation against this present petitioner, only his number was given lordship. Actually, amount was taken by the Raju Ali lordship.
Where is the FIR?
FIR on page 15A lordship.
What is the accusation against you?
Against me, nothing is there lordship. Only my phone number was given lordship.
Where?
Lordship, may I read the entire FIR lordship?
Not entire, relevant part you can.
That words
Which page?
is 15A lordship.
Read the relevant part where.
Uh,
allegation.
So then lordship 1, 2, 3, 4.
When it and tried to contact him.
The phone number also given me another phone number 970-636-224 saying it belonged to his brother. When I contact this number, the person identify himself as a Rahul.
This phone number belongs to you.
That number is given by that Raju Ali lordship. Only that things lordship. I have not taken.
Whose phone number is?
They have given my phone number lordship. Say
It is
my
your
phone number, but I have not taken anything lordship. My phone number he has given. Raju Ali has given to that informant lordship.
Okay. Yes, Mr.
Lakhimpur PS regarding that all of the goal and all this.
Heard
that-
Mr. B. Chaudhary, learned counsel for the
Other is
petitioner.
main culprit already, my lord.
Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely, what is your name?
Khairul Islam alias Rahul.
Khairul Islam alias Rahul, who is apprehending his arrest in connection with Bhipuri IPS case number 107/2025 under section 318 within bracket 4/316 within bracket 2/3 within bracket 5 of BNS 2023. Gist of accusation at page 21, para 3. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR. He submits that the main accused of this case, one Raju Ali, who has already been granted bail by this court,
What are the 6/8/25?
on,
Page 20.
on 6/8/2025 in AB case number 1582/2025 had given the phone number of the petitioner to the informant of this case without his knowledge. Stop. It is submitted by learned counsel for the petitioner that the dispute in this case is between the informant and Raju Ali alias Shahjahan Ahmed. And however, the petitioner is apprehending his arrest as mentioned about his mobile number is there in the FIR. Stop. Learned counsel for the petitioner submits that The petitioner is ready to cooperate in the investigation. We are disposing it of. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. It appears that the main accused of this case, namely Shah Jahan Ahmed alias Raju Ali, had already been granted anticipatory bail by this court on 6/8/2025 in AB case number 1582/2025. As no accusation has been made against the present petitioner, apart from mentioning of his mobile number in the FIR by the informant, this court is of considered opinion that if the present petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of the fair completion of the investigation of Bipuria PS case number 107/2025. Stop. In view of above, the above named petitioner is directed to appear before the investigating officer of Bipuria PS case number 107/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of ₹30,000 with one surety of like amount subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. With above observation, this anticipatory bail application is disposed of.
Highly obliged, Lordship. Obliged. Item 11.
Please, 482 application, Lordship. The petitioner is the Chief Secretary of B. Lassit Sena, Lordship. FIR Lordship found at page 17. It was filed by one City Card Stores Private Limited. Actually, one incident happened there. The one girl was sexually harassed there, Lordship. Thereafter, according to them, we have given shade to the present institution or say and demanded money. That you now will also kindly come to Annexure 2, page 19. The allegation of demand was there. So Annexure 2,
Demand from
demand from B. Lassit Sena. That is the allegation that we have demanded money from them for settlement. Now you'll also kindly see Annexure to page 19. That was given one day ahead, the letter given by B. Lassit Sena. I have translated it, Lordship. Page 19. Dated 28/25. Basically, para 6, you'll also will see, serial number 6. We demanded you in your capacity responsible provide assistance as compensation to a young woman whose modesty was outraged. We expect amicable settlement from you. This is the letter given by them. Thereafter, the present FIR the laws against the present petition. Actually, their demand was that 100% employment should be of the local people and compensation should be given to the girl who was harassed. Thereafter, the present FIR was laws against them. And he is the Chief Secretary. On 28/25, this letter was given to the City Card, and thereafter on 21/8, they have filed a no demand of money. Only that the girl should be compensated, that we demanded. And thereafter he has received notice. He will appear before the IOL.
notice under 35.
35 given Lordship. Para 6 I have stated.
Where is the notice?
Notice I have not annexed, but I have stated in para 6.
When is the date?
On 24/8/25 it was sent.
When you
Para
were-
5 you'll also kindly see. 35/3 BNS dated 23/8/25. Directing him to appear on 24. So thereafter we came before this honorable court.
You did not appear.
I have informed her I was not well. He'll definitely appear.
Yes,
We got non-billable section.
heard
that
Mr.
side.
D. Talukdar, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Sri Sujit Datta, who is apprehending his arrest in connection with Jorhat PS case number 438/2025 under section 308 within bracket 4/351 within bracket 2/3 within bracket 5 of BNS. The gist of accusation in this case is that on (21/8/2025), one Shomesh Chakrabarti of City Card Stores Private Limited had lodged an FIR before the officer in charge of Jorhat Police Station, naming therein 2 accused persons, including the present petitioner, who is associated with Bir Lachit Sena, inter alia, alleging that the petitioner along with the co-accused have made a demand for extortion and have threatened and obstructed the business operation of the petitioner's informant's firm. Where is that accusation of, that is not there in the affair?
FIR is there, incident of extortion and threats that were there.
No, that girl was molested.
The earlier, in the earlier portion, you were still fine. At the background of the case, they have stated. At the outset, it is necessary to state an unfortunate incident of sexual harassment earlier occurred at our Jorhat store premises. The management city card, in keeping with its strict adherence to law, ethics, so immediately disciplinary action against the then store manager, Vicky Sutrodhar, by terminating his service on 28/25.
It
That
is
they
also-
themselves stated.
It is also alleged in the affair that the demand for extortion was made under the background of an incident of sexual harassment which happened in the stores of the informant's firm, and in which the store manager, Mr. Vicky Sutrodhar, was alleged to have committed sexual harassment. Stop. Learned counsel for the petitioner has submitted that the accusation leveled against the petitioner in the FIR are not true. He submits that after the unfortunate incident of sexual harassment of a girl in the stores of the informant's firm, what is Bir Lachit Sena? It is
It is an organization.
the organization to which the petitioner is associated, namely Bir Lachit Sena, had only sent one letter to the managing director of the City Card Store Private Limited on 28/2025, asking for adequately compensating the victim girl, and no demand was made by the petitioner's organization. No monetary demand was made by the petitioner's organization or the said organization. In support of the submissions made by learned counsel for the petitioner, he has produced a copy of the letter dated 28/2025, written by the President and Secretary of the Bir Lachit Sena to the Managing Director of the Petitioner's Informants Firm. The learned counsel for the petitioner has also submitted that the petitioner had received one notice under section 35 within bracket 3 of BNSS, directing him to appear before the investigating officer of this case, of the above mentioned case, on 24/8/2025. Stop. He submits that as the said date has lapsed, the petitioner is now apprehending that if he appears now before the investigating officer, he may be arrested. He further, learned counsel for the petitioner further submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor prays for calling of the case diary. So let the case diary be called for. Let this case be listed again on 24th of September 2025. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, the above named petitioner is directed to appear before the investigating officer of Jorhat PS case number 438/2025 and cooperate in the investigation. If he does so, 30,000.
Within 7 days, he will appear.
Within 7 days, you have to appear. 30,000 interim bail, list accordingly.
Lot.
Please, Your Lordship. Lordship, may kindly find the affair at case 10, Lordship.
What is your case?
Lordship, only section 132 is a non-bailable section.
What is 132?
132 is deterring public servant from doing their duty, Lordship. And to
Whom you assaulted?
actually, there was no assault, Lordship. Lordship, kindly find the, see the affair for that. Lordship. Page 10, Lordship, may kindly see. There was no assault. Respectfully beg to state that we, a team of forest officials of Urang National Park Regional Forest Office went for patrolling in Badli Boirali Chor on 1/8.
Case diary would be.
So, Lordship, may kindly see. There is no.
The
There is-
accusation is preventing public servant.
For that, Lordship, there has to be ingredients, Lordship. There has to be assault or use of criminal force. That is not there in the affair, Lordship.
The accusation is of assault.
No, Lordship. There is no assault, Lordship. Lordship, may kindly see the affair. There is no assault. After arrival, we noticed 6 numbers of illegal houses, but there was no presence of any person. While we started to demolish the houses, 200 persons came there and prevented us from doing duty.
Case diary.
Some of them obstructed us. Lordship, may kindly, some of them obstructed us and incited to assault, but there is no assault, Lordship. And Lordship, may kindly see section 132 of BNS, Lordship. Kindly, Lordship. Lordship. The very first line, Lordship. Whoever assaults or uses criminal force to any person, that assault and criminal force is not there, Lordship, as per FIR.
Criminal force is there. Case diary would be required.
Lordship, may kindly see, this is a shore area and the ancestors of these petitioners were resident of that shore area.
No, we will fix a short date after perusal of the case diary. Heard Mr. M.I. Hussain, learned counsel for the petitioners. How many petitioners are there?
4 petitioners, Lordship.
Petitioners. Also heard Miss N. Das, learned additional public prosecutor. Considering the nature of accusation leveled against the petitioners in the case diary, perusal of the case diary would be necessary in this case. Hence, call for the same. Let this matter be listed. 15(9).
May I please, Your Lordship? Lordship, the allegation in the affair is basically receiving of stolen property. My lord will please to find the affair at page 9.
Yes.
Yes, my lord. Most respectfully, I, the undersigned Sri Pinku Kumar, would like to inform you that on 12/8/2025, I took on rent and loaded the 14-wheeler open body truck bearing number so and so for transporting 6 tons of 600 kg tin from a godown situated at Sonapur, Kamargusi to Galaxy Star Silsar by the invoice number so and so and handed over to the driver Utpal Das. The total price of the materials is 14 lakhs 50,000 so and so. After that, the driver was called to Ma Karni Cargo Messrs at Beharbari for sending the materials, and on 18/8/2025, the said company loaded and sent those to Silsar on the same day, a total of 13 tons. It is to be noted that today the items sent by both the institutions were supposed to be delivered today. However, the driver Utpal Das has switched off his mobile phone since mornings, which has given rise to various doubts in our minds. The driver's phone number so and so, the total value of the so and so is 29 lakhs so and so. So here, basically, we are not the named person in the affair, my lord. On 27/2025, 27/8/2025, we received, the petitioner number 1 received a notice under section 35(3) of BNSS. Then the petitioner inquired about that, and as well as the police has approached the house of the petitioner number 2 also, inquiring about the tin sheets, but they couldn't find any tin sheets regarding that. Then whenever the petitioners have inquired about the case, my lord, they came to know that the persons who have offered tin sheets at a cheaper cost, that person got arrested, my lord, on 28th. So that is our apprehension, basically, my lord. We are not named person. We have dealt with nothing, my lord, and the police couldn't seize anything from our home. But since 35(3) BNSS has been issued notice, that's why we have apprehended.
No, 35(3) should,
35(3) if
because
not
police don't
required.
want to arrest you.
My lord, maybe, but if we appear before the police, there might be, there is, that's why this is the apprehension, my lord. We are ready to cooperate with the police.
No basis,
Both way, my lord. If notice is supplied, then this.
no basis for apprehension.
We are ready to cooperate, my lord.
Not supplied.
And regarding petitioner number 2, no notice has been issued, but police has approached the petitioner's number 2 home also.
You appear tomorrow.
I will appear, my lord,
Tomorrow is the date.
tomorrow.
Let him appear tomorrow.
My lord.
Heard. Mr. B. Deka.
My lord, meanwhile, certificate copy, because certificate copy will not get. Otherwise, after tomorrow, if possible, my lord.
No, but the notice date is tomorrow.
We will appear, my lord.
At least petitioner number 1
One.
should appear tomorrow.
My lord.
Heard Mr. B. M. Deka, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely number 1, Mahataz Khan, number 2, Nawaz Hussain, who are apprehending their arrest in connection with Sonapur PS case number 130/2025 under section 303 within bracket 2/317 within bracket 2/318 within bracket 4/61 within bracket 2 of BNS. 2023. The gist of accusation in this case is that one, who is the informant?
My lord, Pinku Kumar.
One Pinku Kumar had lodged an FIR, on 16/8/2025 before the officer in charge of Sonapur police station, inter alia, alleging that that the informant took a 14-wheeler open-body truck bearing registration number AS01JC 5643 for transporting 16 tons 600 kg of tin from Sonapur, Kamarkuchi to Silchar, and accordingly the said consignment was loaded in the vehicle, and one Utpal Das, driver of the vehicle, was asked to deliver the same to at Silchar. However, on the assigned date when the consignment had to reach the destination, the mobile phone of the petitioner, mobile phone of the driver of the vehicle, namely Utpal Das, were found to be switched off, which has raised the apprehension in the minds of that the paid consignment have been stolen. Learned counsel for the petitioners has submitted that the petitioners are in no way involved in the offence alleged in the FIR. However, petitioner number 1 has received a notice under section 35 within bracket 3 of BNSS asking him to appear before the investigating officer of the Sonapur PS case number 130/2025 on 3/9/2025, that is tomorrow. And as non-bailable offences are involved in this case, the petitioner is apprehensive that he may be arrested if he appears before the investigating officer. Learned counsel for the petitioner also submits that though the petitioner number 2 has not received any notice under section 35(3) of BNSS, however, police is busy searching for him, which has raised the apprehension in his mind that he might also be arrested in this case. On the other hand,
My lord, goods may be sold to several persons. Though 2 persons were arrested,
might have
only portion of the items are already recovered, but others not yet recovered. So there may be material. So CDB.
on the other hand, learned additional public prosecutor submits that the additional public prosecutor prays for calling of the case diary, as the entire consignment which is alleged to have been stolen has not yet been recovered. Stop. Let the case diary be called for. Let this case be listed on 24th of September. However, in the meanwhile, the petitioner number 1 is directed to appear before the investigating officer in pursuant to the notice received by him under section 35 within bracket 3 of BNSS. That is tomorrow within bracket on 3/9/2025, and cooperate in the investigation. If he does so within the stipulated period of time, he shall be allowed to go on interim bail of stipulated period of time in the event of his arrest in connection with above noted case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount subject to the satisfaction of the arresting authority. The petitioner number 2 is directed to appear before the investigating officer within 7 days from the date of this order and cooperate in the investigation. If he does so, he shall also be released on interim bail of rupees 30,000 with one surety of like amount subject to the satisfaction of the arresting authority. Following conditions shall be attached while granting interim bail to both the petitioners, number 1 and number 2,
Much obliged, my lord.
list accordingly.
Only one prayer, my lord. Certified copy may be available today, my lord. Online maybe.
It will be uploaded today.
My lord, much obliged, my lord.
Item 14.
Met your loss. Extortion and cheating, my lord. Nothing new. It's a civil dispute, my lord, when the parent petitioner filed 2 cases before the, my lord, CGM. And when they got the notice, this present case was filed. The master of the school, my lord, background is that, my lord, that our family members donated the land in the name of the school. Subsequently, they have, my lord, misappropriated and ultimately they have transferred the land to somebody else. For that villagers also, my lord, they held a meeting. And thereafter, my lord, some village, so many times, my lord, they also actually several times wanted to settle the matter, they could not do it, my lord. Thereafter, on 20/6, I just take your lordship to one first, my lord, page 18, my lord. Your lordship will find vernacular, page 22. Page 20, vernacular, my lord.
Yes, what is?
Your lord.
Yes.
Yes, English is 18, my lord, vernacular since case number is there, my lord, your lordship. Page 20, your lordship, 503, it is, your lordship, top, my lord. Page 22, Sierra number 503. Your lordship got it.
Yes.
503. Now, your lordship, the present petitioner is the petitioner, my lord, here. And that was filed on 13/6/25. 13/6/25, your lordship, it will appear from page 25.
What are the allegations?
Allegation is, my lord, that this headmaster, initially land was donated to the schools, my lord. And they have actually, my lord, they have already transferred some land to their own relatives without the knowledge of the, my lord, villagers. President, lot mandal, circle officer, all are involved, my lord. So this case were filed in June 2025. That you have to kindly note, my lord. And the order is, your lordship, kindly see, court has taken cognizance on 18/6, my lord. Just my, your lordship, kindly see. That we could annex, my lord, just we got it only yesterday, my lord. This orders, my lord. 2 cases filed, one is 503, your lordship will find, another is 546. Another is 546. 2 cases filed. One is, your lordship will find, that is 503. Date is very important, my lord. Then I will come to that here. And second one is, my lord, page 26, page 29, your lordship, kindly see, my lord. Page 25, 546. Orders of both the cases are very good, your lordship, my lord, just now.
In second case, what is the accusation?
Same, my lord, in spite of filing the RDA case, again, they have, my lord, done these things and they have threatened, etc., my lord. Section is also there, page 29, your lordship will find, right side. And that is date, your lordship find that the second one was filed on B-20-206-25. Complaint date. And order, your lordship will find that notice was issued on. But two orders I have given to your lordship. One is RDA 503, one is 546. So now you have to come to FIR, madam, just take page 16. These are the petitions we have filed, the present petitioner has filed against the informant and his father. The notice was issued only after mother received the notice. The present case was filed, page 16, your lordship, page 16. 16 vernacular and English version is my your lordship, page 11. Page 11 is the English translation and rest is my lord, the vernacular. Page.
What has been alleged against you?
Yes. It is that, my lord, I have tried to, my lord, disturb the development work. Then I have, my lord, along with some others, we have demanded some money. Thereafter, my lord, some disturbance. Basically, that, my lord, he said that the conspiracy cheated me. I do not know what cheated, but nothing we find here in the FIR, my lord. I am the informant headmaster of the school. The accused number one has since long been creating disturbance towards the developmental works of the school and also demanding money from the development funds of the school. Demanding. As the demands are not fulfilled, he creates disturbance in the government works of the school. The higher authorities of the school are also aware about the same. For the last many days, said Numanuddin, that is the present petitioner, my lord, who is the informant in other cases, my lord, and Jubail Ahmad have been involved in disputes with my family members. And on different occasions, they have also threatened to kill them. Accused number two, Jubail Ahmad has also forcibly taken a laptop from the shop of my younger brother. He is not before the worship, my lord. Under such circumstances, on last 16/8/25, your kindly note this date, my lord. Only they have received the notice. Thereafter, this everything is, my lord, cocked up, my lord. 16/8, after the school timing was over, the accused number 2 and 3, my lord. I am not 2 and 3. At the instance of the present petitioner, my lord, projecting themselves officers of the crime branch, identity card, etc., enter my school, informing me and held a press conference in the school, my lord. After some time, the reporters contacted me and after taking my reaction, they left. Thereafter, accused persons met me and a fraud crime branch officer, the accused number 2 and 3, gave me a mobile number, asked me to meet them within 3 days along with the cash book, ledger book, so and so. They asked me to bring that money along with the school documents with a threatening that if I fail to pay the demanded money, they will cause hamper to me. They also threatened me. Subsequently, after contacting those reporters, I came to know that they have given false identification as officers of the crime branch to them. That is regarding 2 and 3, my lord, not the 1. Sir, I am the head teacher. Due to such illegal activity of the school, disturbance are being caused to the official works of the school and also education of the students. The statement of fake inquiry of the fake officer has been published in the newspaper. Sir, accused persons have headed a conspiracy and cheated me, hence finding no way out, I filed this case.
But 2 persons came, identified themselves as a officer, crime branch officer, and at the instigation of the accused number 1. Now accused number 1 is before us, my lord, and demanding money and all this. Yes, maybe in the, as per the FR 2 and 3, but their involvement maybe they are in the city. We have to go for the city, my lord. Serious allegation. If 2 persons came, being identified themselves as crime branch officer, held a press conference in the
school itself.
School itself, but subsequently reporter has stated that I come to the giving false identification as officer of crime branch.
Is not petition. That accusation is not against
at the instigation of the petitioner. He directly not come, my lord, because he known by the others, my lord.
his identity is known by the headmaster because he directly not come. Maybe my lord, that story, my lord,
When the case was filed, my Your Kindness. FIR.
that thing, my lord,
Only after I received the notice of those two cases, my.
we have to go by
That is
the.
the case, but I
You are
think.
appearing for?
For-
You have objections?
The much prior to this incident, the petitioner was threatening the informant. And there are every chances of tampering the evidence and influencing the witnesses also.
At this stage, maybe my lord.
Notice has not been issued, my lord.
Maybe
How
call.
clear now. You only matter only because of the two cases long back, 2 months prior to that.
But if it is comes to the light, my lord, some persons, my lord, identify themselves as crime branch officer. Maybe
I
as
am
per
not them, yes.
maybe as per the as per his instigation, he is known to the informant, my lord, headmaster. So he directly don't come, my lord. He sent some other persons, my lord. And it should be, my lord.
Only
reviewed
for the
from
purpose
city,
of
my lord.
opposing a bail matter. that
Heard
not-
Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. I.U. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, as well as Miss, what is your name? Khushbu Verma, appearing for the informant. This application under section 482 of BNSS has been filed by the petitioner, namely Numan Uddin, who is apprehending his arrest in connection with Badarpur PS case number 149/2025 under section 308 within bracket 2/304 within bracket 2/319 within bracket 2/318 within bracket 4/329 within bracket 3/132/351 within bracket 2 of BNS. The gist of accusation in this case is that on 19/8/2025, one Ahmad Bashirul Islam had lodged an FIR before the officer in charge of Badarpur police station, inter alia, naming 3 accused persons therein, including the present petitioner, stating that the petitioner has been creating disturbance in the developmental works of the school, of which the informant is the headmaster. It is also alleged that the petitioner has also demanded money from the developmental fund of the school. And he used to threaten the family members of where is the vernacular?
Vernacular is my FIR.
Yeah.
FIR vernacular is paid. Your lordship 16.
When that threatening was given,
So that is there, date is not given, only 16/8 they have taken matter of crime officer, and the 13 date is not there.
threatened,
Page 16, minor
okay, threatened to kill them. It is also alleged in the FIR that at the instance of the present petitioner, the accused number 2 and 3 came to the school of the informant and projected themselves as officers of the crime branch and held a press conference in the school premises. Stop. It is also alleged that The accused number 2 and 3 also demanded an amount of rupees 50,000 from the informant. Stop. It is also alleged that the conspiracy to cheat the informant was made by the present petitioner along with the other two co-accused. Stop. Learned senior counsel for the petitioner has submitted that the accusations leveled against the petitioner in the FIR are not true. He further submits that the accusation of impersonating as crime branch officers are made only against accused number 2 and 3 in the FIR, and no specific accusation has been leveled against the petitioner. He further leveled against the petitioner. He further submits that the lodging of the present FIR on 19/8/2025 is a counterblast by the informant to the complaint case lodged by the present petitioner against the informant on against the Bashirul Islam, against the informant on 13/6/2025. He submits that on the basis of the complaint lodged by the present petitioner, one CR case was registered that is CR case number 503/2025, and cognizance of offense was taken by the trial court on 18/6/2025. Learned senior counsel further submits that subsequent to the lodging of the aforesaid complaint case, the petitioner again lodged another complaint case, which was registered as CR case number 546/2025. In which case, and in this said case also, the cognizance was taken by the learned magistrate on 26/6/2025, and summons were issued to the accused persons named therein, including the present petitioner, including the informant Bashirul Islam. He submits that after receipt of the summons from the court in both the cases, the informant had lodged a false and concocted FIR against the present petitioner, in which main accusation has been leveled against respondent number 2 and 3. So, on the other hand, learned senior counsel for the petitioner has also submitted that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has submitted that since accusation has been leveled against the present petitioner also, that it is at his instance, accused number 2 and 3 projected themselves as fake crime branch officers. The case diary may be called for. He also objected to grant of any interim protection at this stage. Stop. Similarly, Ms. Verma, learned counsel for the informant also objected to grant of any interim relief and submitted that as the petitioner has been threatening the informant, if the petitioner is granted any interim relief at this stage, he may tamper with the evidence and influence the witnesses of the case. I have considered the submissions made by learned counsel for both sides. Perusal of the case diary would be necessary. Hence, call for the case diary. Let this case be listed on 22nd of June. It's September. However, in the meanwhile, considering the submissions made by learned senior counsel for the petitioner, as discussed in the foregoing paragraph, as well as considering the fact that the main accusation of impersonation as crime branch officers is against the petition, against the accused number 2 and 3 of the mentioned 2 and 3 mentioned in the FIR, as well as considering the fact that the accusation against the present petitioner that he has been threatening the informant is a general accusation without mentioning any specific date as to when such threatening was given by the present petitioner. This court directs the petitioner to appear before the investigating officer of Badarpur PS case number 149/2025 within a period of 7 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be granted interim bail of ₹30,000 with one surety of like amount subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2, list accordingly.
Item 42 from supplementary.
It may be possible for the time being, Lordship, as Mr. James is on the line.
Last one.
Bail bearing via item 16 and 17.
Charge sheet submitted, my lord.
Sheet submitted.
My lord, may call for the scan copy of the, my lord, report, my lord, then, my lord.
What is the matter?
My lord, this is, my lord, the NDPS case, my lord, so far, my lord, the petitioner in the first case, my lord, the intermittent quantity has been, and my lord, recovered from them, my lord.
No, you convince the trial court.
But, since the April, my lord, this matter is pending before this honorable court.
No, but there is no
My lord.
bar for the trial court to consider after submission of charge sheet.
Recently only submitted, my lord, it will.
Heard Mr. U.J. Sakia, learned counsel for the petitioner.
Scan copy of the, my lord.
No, why to jump one forum? When trial court itself may grant bail. It is intermediate quantity.
They will do the one from.
My lord, yes, from the petitioner, my lord, intermittent quantity has to be required.
If it is intermediate quantity, then trial court may consider your prayer. Heard Mr. U.J. Sakia, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
76/2025 dated 27/8/25.
Stop. In view of the submission of the charge sheet, this bail application is disposed of with an observation that the petitioner may approach the trial court and may file regular bail application before the said court, if so
76 of
advised.
2025.
Item 18.
Same is what.
16, 17, same orders, same orders.
76, that is 27, 825.
Please, your lordship.
Charge sheet number
76 of 2025.
dated
27, 825.
in both the cases, same case, similar, same orders, 2 copies. Yes,
Lordship, in this case, lordship, the petitioner is behind the bar, lordship, 755 days, lordship, 2 years, 24 days.
Well, last occasion, a report was called for. A report has come, flag P.
what
Yes.
report was called for?
How many witness examined, and there were some few eyewitness. Next page, may see, next page the report, as per a report dated 6/8/25.
This is a POXO case,
No,
No.
NDPS.
Murder. Out of 39 witness, 5 witness still examined, and PW21 Surat Setri, he saw the accused person having dagger, went inside the jungle, and 3 eyewitness, Rajan Pradhan, Kabiri Gogoi, and Tulsi Ram, they are yet to be examined, these eyewitness are very much vital,
Lordship, that status was called for from the
That's
trial.
the-
They have to
come-
be examined after.
Lordship, otherwise, lordship, more than 2 years, lordship, and I have taken
No,
the.
but this is a murder case.
But Bihan Kumar, I have taken plea also, lordship. I have annexed the notice, lordship. And more than 2 years, lordship, and 39 out of 39, only 5 examined.
39, I am on, last occasion also my submission was that till the eyewitness be examined, because of that report has been called for, 39 also, but at least this eyewitness,
Yes, Vihan Kumar.
Lordship, Bihan Kumar, I have taken plea last occasion, I also supposed to submit, lordship. But if notice 50 and 50 both, lordship, there is no grounds of arrest, lordship. Lordship, the
No,
petitioner, lordship, will not try to hamper and temper the.
no, you cannot, how you can be relied upon? This is a murder case.
Murder case, he, petitioner,
More than 2 years.
with the person went inside the jungle with the dagger. Subsequently, they came out. Surat Setri statement I have read, I have gone through, and they stated that the informant asked them, where is the person, other person? He stated that he is coming. Subsequently, his dead body was found inside the jungle, Serious case,
Though the matter is very serious, lordship, it is admitted, lordship. But still, lordship, from legal point, lordship,
Where is your plea?
lordship. Lordship, page 33, 32, page 32 and 33, lordship. I have annexed notice 50A and the inspection memo, lordship. And notice under section 50, I have flag mark, lordship. And I have copy of notice 50 also.
kidnapped a person and subsequently murdered.
How will you overcome 50?
Grounds of arrest in such cases,
More than 2 years, lordship, and for rest witness, lordship, it will go so long, lordship. And if any strict direction may be given, lordship.
No,
In the forwarding report, grounds of police remand, that is there, page 15.
where is that notice? Putul, record. No, record.
No. And as per the letter judgment, we have to see what prejudice he has to be. That is also important. He, one person has been kidnapped and subsequently murdered. Minor son.
Therefore, it is more important, it is necessary on the part of police to follow all procedural requirement in.
Yes, at that time, that was the practice, the practice that following the judgments which were held at that point of time, that is given, and grounds for police remand, that is also given in the forwarding report. Detailed grounds of arrest is there in the forwarding report, that is there, it's not that the satisfaction of the magistrate also be taken into care. When the forwarding report, may see forwarding report, page 14.
Where is forwarding report?
Page 14, Page 14, they have annexed. In the main petition itself, grounds of arrest, during the investigation, detailed mobile number so and so was collected, and mobile number identified Abhishek Borwa. Accordingly, he was searched, and during search appeared that along with his scooty number so and so used for kidnapping the minor son of the complainant, and mobile handset which was used for demand ransom. Ransom was demanded. During interrogation, the accused person, he acknowledged the offense and that he kidnapped the minor child of the complainant from the way to the school at the morning hours and kept under his control. On the date of occurrence, the arrested accused person brutally stabbed to death at Bunda Forest near the stream using a sword and changing uniform of the victim. These are next page also, my lord.
Forwarding.
One person, in some other cases, yes, one person carrying something, it has to be proved. In case of NDPS also, it has to be official report also, maybe, now he brutally kidnapped a boy, murdered him, demanded ransom before that, and he has to be grounds of arrest, yes, but satisfaction of the grounds of arrest details has been given when he was forwarded. And forwarded.
No, it has to be given to the accused.
It has to be given, but the satisfaction of the magistrate also, and at that point of time, it was not police did not follow the strict rule, because of that there was no such a judgment. At that time, point of time, the judgments which will prevail, they were followed.
Heard Mr. K. Thakur. Learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Abhishek Borwa, who has been detained behind the bars since 9/8/2023, within bracket for last, how many days?
755 days.
755 days. in connection with Sessions Case number 231/2023 arising out of Bashishta PS case number 474/2024 under section 364/302/201 of the Indian Penal Code. The petitioner is facing a trial before the Court of London. Which court?
Additional district and session judge Nong 3, madam. Kamrup Metro.
Before the Court of London, additional district and session judge number 3,
Kamrup Metro, madam.
Kamrup Metro. Under section, charges were framed under what provision? Under section 3.
As order, I have annexed.
Where is this?
Lordship, it is on page 18, Lordship. 30.
Under section 302/201
364A.
slash
364A.
364A/34 of the Indian Penal Code.
34 is not there, Lordship.
Only he is facing trial.
Yes, sir.
Is 364A.
364
And to
Plus
the
20.
and 201 34 na lage of the Indian Penal Code. Stop. On the last occasion date, this court directed the trial court to furnish a status report regarding the stage of trial, and it has been stage of trial stop. Accordingly, the trial court has furnished a status report. Stop. On perusal of the same, it appears that out of 39 listed prosecution witnesses, only 5 witnesses are examined till date. And there are 3 more witnesses, namely Rajen Pradhan, Kaveri Gogoi, Tulsiram Newpen, who are stated to be eyewitnesses and who have not yet been examined by the trial court. Stop. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars for more than 2 years, and out of 39 listed prosecution witnesses, only 5 have been examined till date. He also submits that the petitioner has approached this court for bail, seeking bail, mainly on the ground of violation of his fundamental rights guaranteed to him under Article 22 within bracket 1 of the Constitution of India. He submits that in this case, at the time of his arrest, though notice under section 50 of the BNS 50 of the CRPC was served on him. However, it does not contain in detail, it does not contain the basic facts which necessitated the arrest of the petitioner in the aforesaid case. He submits that you are relying on,
behind commander.
he submits that no, stop. learned counsel for the petitioner submits that the apex court in the case of Vihan Kumar versus State of Haryana reported in 2025 5 SCC 799 has observed that communicating the grounds of arrest in writing to the petitioner, to an arrestee at the time of his arrest is a mandatory constitutional requirement. And any infringement of the said requirement would amount to infringement of the fundamental rights of the such an arrestee, which would render the arrest of such an arrestee illegal. And on that ground, he may be allowed to go on bail. Stop. It is also submitted by learned counsel for the petitioner that while communicating grounds of arrest to an arrestee, basic facts which necessitated the arrest must be communicated to him, which has not been done in the instant case. Hence, he is entitled to get bail in this case. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the present petitioner. Stop. He submits that in this case, an innocent child was
15 years.
an innocent child was kidnapped and murdered. And there are materials on record to show that the petitioner, there are sufficient incriminating materials against the petitioner on record. So he submits that out of the 5 prosecution witnesses who have already been examined by the trial court, the PW5 has categorically, PW2 or 5? Surat Chetri, PW2 has categorically deposed that he saw the petitioner with a dagger on the date of occurrence of offense, along with the deceased, were entering into the jungle from where the dead body of the deceased was later on found. He further submits that in this case, 3 more eyewitnesses are yet to be examined. And if the petitioner is allowed to go on bail at this stage, there is every likelihood that he would threaten the witness and may influence those witnesses. He has also submitted that regarding 47, he has also submitted that in this case, notice under section 50 was served on the petitioner. However, it does not contain in detail the basic facts which necessitated his arrest. He further submits that at the time of production of the petitioner before the before the magistrate after his arrest, in the forwarding report, grounds of arrest were mentioned in detail in the said forwarding report. He also submits that the petitioner has failed to show any prejudice
Yes.
caused to him due to non-furnishing of ground of arrest to him in detail. And therefore, he opposes the grant of bail to the present petitioner. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record, including the scanned copy of the records of the sessions case number 231/2023. Though the case involved in this, though the accusation made against the present petitioner are very serious in nature, and this case involves unfortunate incident of kidnapping and killing of an innocent child. However, the fact remains, until the accusation are proved in the trial, the petitioner would be deemed to be an innocent. Stop. Considering the nature of the accusation leveled against the petitioner, it was incumbent on the arresting authority to strictly follow all the mandatory requirements at the time of the arrest of the petitioner. However, in the instant case, on perusal of the notice, copy of the notice under section 50 of CRPC, which is available in the case record, it appears that same does not contain basic facts which necessitated the arrest of the petitioner in this case. The apex court in the case of Vihan Kumar versus State of Haryana within bracket Supra has observed as follows. Quote para. Twenty 26.1 to 26.6 from the Vihan Kumar. Stop. In cases where offenses of serious nature are involved, it is incumbent on the police/arresting authority to meticulously follow the mandatory procedure prescribed by the statute as well as by the Constitution of India, so that due to non-following of the said procedure, the petitioner, the accused in such cases, does not get benefit of bail. However, where the infringement of the fundamental rights of the petitioner are apparent from record, there is no option for this court but to follow the mandate of the apex court as discussed herein above in the aforesaid judgment of Vihan Kumar versus State of Haryana. Stop. For the reasons discussed herein in the foregoing paragraph, the petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount. What conditions may be imposed?
In the trial process, he has to,
With following conditions.
each and every day he has to appear.
5 trial conditions. It is also next condition, any violation of violation of any of the above mentioned condition would be good ground for cancellation of bail of the present petitioner. With above observation, this bail application is accordingly disposed of.
May it please lordship, question is a POCSO matter. Service is completed.
Service is complete. Amicus has to be appointed. Any amicus is present in the court? Yes. Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned additional public prosecutor has submitted that the notice issued to respondent number 2 has been duly served. Stop. However, no one has appeared on behalf of respondent number 2 in this case. Hence, this court intends to appoint one amicus curiae to defend the cause of respondent number 2 in this bail application. Accordingly, Ms. M.K. Brown, learned counsel, whose name appears in the list of amicus curiae prepared by the registry of this court, is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. The learned counsel for the petitioner is directed to furnish a copy of bail application along with annexures to the learned amicus curiae during the course of the day.
5th of September may can be fixed.
No, when will you furnish the copies? Today itself. Today itself. The registry is directed to reflect the name of Ms. M.K. Brown as amicus curiae for respondent number 2 in this case. Let this case be listed when? Yes, 15th September, 5th of September. 5th of September.
Apply.
In this case, Lordship, I am going to file an additional affidavit, Lordship, because Lordship, the family member of the petitioner, Lordship, they are going to provide a document today, Lordship. So, Lordship, with the additional affidavit tomorrow, day after tomorrow, Lordship may take up, Lordship, because we have raised a question regarding this minuscule amount of the contraband seized, Lordship. That is why, Lordship.
No,
Almost Lordship heard,
what you intend to?
Lordship, with all the documents, Lordship, if Lordship take up then this will be better for us.
Heard Ms. S.K. Nargis, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner prays for allowing the petitioner to file an additional affidavit to bring on record certain facts as well as certain documents which are relevant for consideration of the instant bail application. The prayer is allowed.
On fifth, Lordship, if possible.
When?
On fifth, Lordship.
Let this case be listed again on 5th of September.
Item
22.
Please leave your lordship. Lordship has earlier rejected this application. This is for second time and 43 days today, Lordship, from 27/2024, 25.
Case diary is
40
there.
43 days, Lordship. Here, Lordship,
What was the allegation?
the allegation here regarding Lordship, that he has by kind of blackmailing, engaging someone, he has
Lordship will remember by using different IDs, he blackmailed
Yes.
his own girlfriend, Lordship, and demanded money.
Okay.
Yes, yes.
acquisition, Lordship. Here, and no video has been viral, Lordship. And
Now, what is the
nothing-
stage of investigation?
Substantially progressed, Lordship.
Okay, heard Ms. T. Som, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application has been filed, and this application under section 483 of BNSS has been filed by the petitioner, namely Sayan Roy, who has been detained behind the bars since 27/2025, within bracket for last 43 days in connection with CID Cyber PS case number 5/2025 under section 308 within bracket 2/351 within bracket 4/3 within bracket 5 of BNS, read with section 67A/67D of the Information Technology Act. The gist of acquisition in this case is code para 3, 4, 5, 6 from page 17 of the affair. Learned counsel for the petitioner has submitted that the petitioner is approaching this court for the second time. Stop. She submits that his earlier application for bail was dismissed on 8/8/2025 within bracket bail application number 2442/2025. She also submits that nothing has been uploaded in the social media, though the accusation has been made against the petitioner of uploading the indecent programs of the victim in the social media. Off করে দিও। क्या लिखा? She also submits that considering the period of detention undergone by the petitioner, he may be allowed to go on bail, as by now the investigation might have progressed substantially. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Cyber PS case number 5/2025 and has submitted that though there are sufficient materials against the petitioner in the case diary, The investigation has fairly progressed by now. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary of Cyber PS case number 5/2025. Stop. Considering the progress made in the investigation as well as period of detention already undergone by the petitioner, this court is of considered opinion that if the petitioner cooperates in the investigation, his further custodial detention may not be necessary for fair completion of the investigation of the above noted case. Stop. In view of above, the petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Kamrup Metro with following conditions. Number 1 and number 2. Send back the case diary. This bail application is accordingly disposed.
May it please your lordship. My lord will kindly come to the affair at page 19, my lord.
The PP would be required.
Yes.
Special vigilance. You have to
What is that?
inform.
Yes. It is on
Mr. P. Kotoki,
Photo.
let him come.
Yes.
We'll take some other item.
My lord.
May I please, your lordship, kindly pass over this matter for the time being. Mr. KL is on legs.
Okay.
Item 45.
May it please, lordship. Lordship, NDPS matter in intermediate quantity and custody period is 59 days today.
Heard Mr. M. Rahman. CD is there.
Oh, look.
Heard Mr. M. What is the quantity
147 gram.
of heroin?
Opium.
Opium?
Yes.
Yes, Mr. Sharma. 60 days is the.
Yes. So I don't have the copy of the petition also, lordship.
Furnish a copy of the petition. You have extra copy.
Okay, lordship.
Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Vikas Kumar Singh, alias Shyamal Bishnoi, who has been detained behind the bars since 6/7/2025 within bracket. You have calculated properly
Yes, sir.
for last 59 days in connection with DFU PS case number 57/2025. What is the commercial quantity of opium?
Can this matter be taken up after some time, lordship? I have some doubts in this case, lordship.
Okay.
Last time it was
After some
confirmed. Last time it was
It's
confirmed.
okay.
with interview.
Just I will like to make some submission, lordship. At 2, lordship.
Okay. At 2. You find out what is the commercial quantity. We'll take it up at 2.
Lordship.
Item 23.
Yeah, please, lordship.
My lordship, this is the third bail application, anticipatory bail application.
Third.
Yes, my lordship. I am head teacher of the school, my lordship.
What is the stage?
It is in the investigation stage, my lordship. In this bill application, my lordship, I am relying on a annex, my lordship, which is at page 25, my lordship. My contention is that I am a victim of conspiracy, my lordship, and this annexure proves the fact. Annexure 25. I have also one document from the other witnesses which they have submitted before the district elementary education officer by stating that they have wrongly filed a case against me. So my lordship, I am a victim of conspiracy here. Either
What is this annexure 25?
my lordship, it's a document, the vernacular is on page 28, my lordship. It's a document executed by the informant, my lordship. May I read in vernacular or in English, my lord?
Yes, read the vernacular.
যেহেতু প্রথম পক্ষ জুয়া ইংরেজি 26/12/2024 তারিখে ভারপ্রাপ্ত আরক্ষী বিষয়া মরিগাঁও থানার দ্বিতীয় পক্ষর বিরুদ্ধে এটা ফৌজদারি গোচর রুজু করেছিল এই মর্মে বিভাগীয় কর্তৃপক্ষ
You have instructions, Ms. Brown, regarding this document.
Sir, I would like to make some submission regarding that. This aspect has already been dealt by your lordship. Basically, lordship, this document suggests that the complainant has no grievance against him. So that is the basic.
No grievance against the petitioner.
And they do not have any objection if he gets bail, lordship. That is the meaning of that annexure. That aspect has already been dealt by your lordship in the second rejection of that.
No, my lordship, some difference is there, my lordship.
Lordship will kindly come to the second rejection order. It starts at page 21, lordship. Lordship will kindly come to page 23, the 11th portion I'm submitting, lordship. Page 23, lordship.
Yes.
First paragraph, lordship, third line, he further submits.
Yes.
He further submits that though the informant has filed an affidavit not opposing the bail, however, during the investigation, it has come out that it is not only the daughter of the informant who was the victim of the sexual harassment by the petitioner, there were other victims also who had suffered at the hands of the petitioner, and their statements were recorded under 183. On the other hand, HA Law School Learned Counsel for the informant has submitted that though the allegation leveled against the petitioner in the FIR true, however, the informant is not opposing the anticipatory bail. And considering this aspect.
This page number 21.
I have not annexed it. This page was
But
not.
you have taken this plea earlier
No,
also.
my lordship, in that plea I have not taken.
But it is reflected in the order that you have
At that
taken.
time, the advocate of the legal counsel of the informant was present. And it was his submission. After that, I got this document and another document, my lordship. Kindly, there is that document, my lordship, which they have all the witnesses they have submitted before the district elementary education officer. My contention is that, my lord, I am the victim of conspiracy, my lordship, because I am the headmaster and they wanted me to host from the school, my lordship. That's why they framed the whole story, my lordship. A new investigation is required. my
Case diary is there.
Kindly see, my lordship. This document, my lordship, police investigation, my lordship, they should consider this one also. If they give statement against me, then why they are giving such kind of
What is
document?
this document?
My lordship, the witnesses, my lordship, who has stated against me that I have done wrong things, my lordship, they have submitted this document before the authority of the school, my lordship, district elementary education officer. I am the headmaster. The real story is that, my lordship, some of the members of the SMC, my lordship, they want me to be transferred to some other school, my lordship. That is the main. I
No,
am the
you cannot produce document in this way.
my lordship, just for, I have police, I can produce this document to the
This is not
council. It is the police can take this, consider this document for investigation purpose, my lordship. If they have stated anything against me, then why they are submitting such kind of documents to the authority, my lordship? And this
You might
document-
have pressurized them.
No, my lordship, I cannot pressurize all the witnesses. I have no such power. I am a simple head teacher, my lordship. That's why, my lordship, it is either it is a.
No, if you are relying on some document, you file it in the form of additional affidavit
Okay, my-
with a copy to the other side so that they can take instructions.
My contention is that. my-
Otherwise, your document 21, document on which,
This document I have annexed first, my lord, in the
no,
RTF.
but you have taken that plea.
No, my lordship, I have not taken that.
That is on record.
My lordship, my plea was that, my lordship.
That plea was considered earlier also. So on that plea that the informant is not opposing,
This regarding the bail, she was not opposing. This document I did not have at that time.
which document?
This document on the informant, the petitioner supplies this document after this, after.
Let the amicus take instruction from the informant. Informants,
Yes, ma'am.
and you want to bring any other, this document on record?
This document I'll bring on record because all the witnesses they have
Heard Mr.
submitted.
S.P. Laskar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Miss M.K. Brown, learned legal aid counsel appearing for respondent number 2. This is for the third time the petitioner has approached this court seeking anticipatory bail. Stop. On earlier 2 occasions, his prayer for grant of anticipatory bail was rejected. Stop. Learned counsel for the petitioner submits that petitioner may be allowed to file one additional affidavit to bring on record one document which has relevance in consideration of the instant anticipatory bail application. The prayer is allowed. Let this case be listed again on 15th of September.
So I
The-
may also be allowed to update the
the-
CD docs.
Stop. The petitioner is allowed to file the additional affidavit. He shall do so by furnishing a copy of the same to learned additional public prosecutor as well as learned amicus curiae. On the other hand, learned additional public prosecutor submits that though the case diary is available, he may be allowed to get an updated case diary in this case. The prayer is allowed. Send back the case diary to be called again after updation. List accordingly.
Highly obliged.
You may take back this one.
Can it be on 16, Lord?
16th
16th of September.
16th of September.
Highly.
Item number.
My lord, will kindly come to page 19, my lord. The FIR. With reference to the subject cited above, I have the honor to submit herewith a FIR concerning the issuance of economically weaker section certificate in the name of Ijaz Yusuf Ahmed, Inspector of Tax so-and-so, by Sri Lokhyajyoti Das, that is the petitioner, ACS, the then circle officer, Dispur Revenue Circle. During the course of investigation of Vigilance PS case number 8 of 25 and 9 of 25 by Inspector Pranab Boysa of Vigilance PS, a charge was conducted at the residential premises of the accused persons of both the cases who are brothers, where Sri Ijaz Yusuf Ahmed was also found present. It was thus confirmed that the aforementioned premises also serve as a residence of Ijaz Yusuf Ahmed. The 2 brothers are involved, my lord. During the course of investigation of the Vigilance PS case number 9 of 25, Sri Ijaz Yusuf Ahmed, brother of the accused, was summoned to record his statement. In his statement, he revealed that he is currently serving as Inspector of Taxes in Jorhat and was inducted into ACS Allied Service in 22 under EWS category. To verify the issuance of the EWS certificate, a requisition was sent to the Circle Officer, Dispur Revenue Circle, Guwahati, seeking confirmation whether as certificate number so and so and so and so was issued in accordance with the Government of Assam's guidelines. Certified copies of all documents submitted by the applicant at the time of the application were also requested. Additionally, a letter was sent to Assam Public Service Commission by memo dated so seeking details of the certificates submitted by Ijaz Yusuf Ahmed during his application for combined competitive examination. In response, the registrar APSC provided all the relevant documents submitted by applicant, including EW certificate duly certified by Lakhojyoti Das ACS, the then circle officer, Dispur Revenue Circle. Now, this is very important, my lord, that the report from the present circle officer revealed that original documents submitted by Ijaz Yusuf Ahmed for obtaining the EWS certificate are missing and could not be located. Reportedly due to office record relocation during construction of CDC office building. However, a fresh field verification was conducted with the following facts emanated. So, my lord, original records based on which the economically weaker section certificate was issued by the petitioner, those are not available. However, a file was reconstituted, my lord. Now, if your lordship would kindly come to para C. Field verification was again conducted on 13/6/25, during which it was found that Ijaz Yusuf's father, Salahuddin Ahmed, is the recorded owner of a plot of land measuring 4.2, that is 1 kotha 11 lecha, covered by Dag number so and so of Beldola Moza as per Jamabandi record mutated on so and so. A 3-storied RCC building is constructed on this plot with a total built-up area of so and so. As per SOP for EWS certification, an applicant or their family must own not more than 1.10, that means 1 kotha 10 lecha, in a notified municipal corporation area or a residential house with a built-up area of 1,000 square feet. So, my lord will kindly note, my lord, this certificate was issued on 27/2/2020. And this verification was done on 13/6/2025. Now, my lord, land should be 1.10 kotha, it is 1.11 kotha. And the building should be 1,000, it is more than, it is 2,005-6. Now, my lord will kindly see, in view of the above, it is requested that a criminal case be registered against Lakhojyoti Das ACS, the then circle officer, Dispur Revenue Circle.
You issued the EWS.
I issued, sir, in 2000, and so eligible, thereby denying rightful opportunities. Now, my lord, the circular which have annexed, my lord, memorandum is at page 23. Apart, there is no dispute, my lord, regarding 1.5 bigha, lordship finds on top, and 1.5 kotha, and built up area should not be more than 1,000 square feet. Now, if your lordship would kindly come to 5.4, my lord. Appointing authority should, in the offer of appointment to the candidates claiming to be belonging EWS, include the following clause. The appointment is provisional and is subject to income and asset certificate being verified through proper channel, and if the verification reveals that the claim to belong to EWS is fake, the service will be terminated. And most importantly, the last 2 sentences, my lord, the appointing authority should verify the veracity of the income and asset certificate submitted by the candidate through certificate issuing authority. Now, my lord, other than the petitioner, my lord, against nobody else any action has been taken. My lord, I as a circle officer, I rely upon the report of the Lat Mondal. Now, I have stated that if your lordship would kindly come to paragraph 3, subpara 4, my lord, at page number 8. Subpara, page 8. That the accused petitioner states that while the accused petitioner was serving as circle officer of Dispur Revenue Circle, Guwahati, the accused Sri Ijaz Yusuf Ahmed had submitted an application by enclosing all original documents for obtaining an EWS certificate. The accused petitioner herein states that prior to issuance of the EWS certificate to the accused, Sri Ijaz Yusuf Ahmed, a field verification was conducted by concerned Lat Mandal. And thereafter, upon completion of the field verification, the concerned Lat Mandal had submitted a report. It is noteworthy to mention herein that after meticulously examining the original documents submitted by the accused, Sri so-and-so, and upon perusal of the report submitted by concerned Lat Mandal, accused petitioner, who was then serving as circle officer, had issued EWS certificate to the accused so-and-so, so-and-so. So, my lord, I relied upon the report and the original records are not there. And the construction is not a static thing, my lord. In 2020, when the verification was done, then the building was not there. How can I be blamed, my lord? I am already under suspension. I am under suspension since, my lord, 1/2/24. And the case has also been registered under PC Act, my lord. There is no allegation as such. My humble submission is, my lord, the original documents based on which this certificate was issued.
Now this PC Act case is pending investigation.
Yes.
Okay. Yes.
My humble submission is, my lord, lordship will call for the CD, but my lord will protect me, my lord. As such, my lord, today, my lord, what do I do, my lord? And I'll cooperate with the investigating agency, my lord.
Yes, Mr. Dutt.
May I please, your lordship, with great respect to my learned eminent senior, may I submit that this is a case, lordship, of an officer who has flouted the all norms of issuing EWS certificate, and he does not deserve to be protected because, lordship, this case is not a solitary
No,
case.
whether his detention is required or
Yes,
not.
lordship, my learned friend has submitted that record is missing. We are also searching those records. A record is missing from that period, lordship, as we have gathered the information, lordship. After issuing this certificate, and this certificate was issuing to one Ijaz Ahmed, and who was that, lordship? He is a brother of one ACS officer and was ALRS officer. There are three brothers, lordship. One is Masum Yusuf Ahmed, who happened to be ACS officer, who has been kept in custody by CM Vigilance for acquiring disproportionate asset. And another is Tanbir Yusuf Ahmed, who is a ALRS officer, lordship. He is also under the custody. And this petitioner, before your lordship, is the brother of that Masum Yusuf Ahmed, who was also an SCS officer and working as a circle officer. And the present petitioner, before your lordship, was also a circle officer. The present petitioner, in order to give an undue benefit to the brother of his colleague, has issued the EWS certificate, and it is a totally false certificate, lordship.
Okay, that is the accusation.
This is the accusation. And
Now why do you require his?
because, lordship, the document is first thing missing, lordship.
But he is under suspension.
He is under suspension, maybe, lordship, but in order to honor the actual gamut of the case, his custodial interrogation is very much required, lordship, because he is not an ordinary man, lordship. He is a habit of committing crime, lordship. Earlier, he was arrested in 2 cases, lordship. He is facing, lordship, may I refer to one order. If lordship allowed this protection to this type of petitioner, lordship, and the various adverse effect goes to the society, lordship.
What is this?
Yes, lordship, this is the prosecution sanction order in respect of the present petitioner, lordship, in another cases, lordship. He was arrested, lordship, in Gontuk PS case, lordship, for land grabbing matters, lordship. 2 cases he was arrested, and government has already granted prosecution. So a habitual offender, lordship, accused, cannot get any protection or leniency from this court. And so far as this present case is concerned, lordship, the matter goes to the root, lordship, because lordship can see EWS certificate was issued, or that system was brought by the constitutional amendment to give some benefit to some needy person, lordship, who was deprived from the benefit of reservation. For this type of certificate, false certificate, some needy people, needy candidate has been deprived from getting job, and this type of undeserving candidate has been getting job. And the lordship, another.
When can you produce the case then?
As soon as possible, lordship can direct, lordship. But my prayer, lordship, for this petitioner, that interim protection may not be granted, lordship. That document is still missing,
And he has very deep root in that office, Lordship. For many times he was serving in there, that Sakul office.
No, but now he is suspended.
Maybe suspended, but Lordship, still he has whole Lordship. We have
How?
some information.
How?
Lordship, some case, Lordship, I will produce in a case diary. I cannot say
Right,
it
he
in openly.
He is
Lordship.
submitting from his own source.
No, not, I'm for
Yes,
instruction,
yes,
Lordship.
yes. Milord will kindly come
I
to
cannot
page
say.
20, Milord. Now regarding, he says that record is missing, therefore I am responsible. Please come to para 6 of the
that is
affidavit.
only the one
No, you
aspect.
cannot improve the FIR.
No, that is one aspect.
The report from the present circle officer dispute revealed that original documents submitted by Rizal Yusuf Ahmed for obtaining EWR are missing and could not be located, reportedly due to office record relocation during construction of CDO, not because of anybody's wrongdoing, because supporting in the shifting process, my lord, it could not be relocated. But my learned friend is saying something else. As if, my lord, everything he knows from his personal source. He is appearing as a public prosecutor.
Yes.
See, you have a duty to bring to the notice of the court both inculpatory and exculpatory part.
Yes, I know.
Not only that, you should only bring to the notice of the court
You
or
address
the
the court.
inculpatory part.
You address the court. I am
Yes, I am addressing the court.
Not to pointing finger. This is not expected from a senior advocate.
When can you bring
Lordship,
the,
even tomorrow, Lordship, I can produce, Lordship. But
tomorrow you can produce?
Lordship,
Let us peruse the case.
Lordship.
Tomorrow I'll be not there.
Day after tomorrow.
Friday.
Friday.
Today I'm going to Itanagar actually.
Heard.
Only thing is, Lordship will kindly protect me.
Lordship will have.
Or day after, on Friday, on perusing the case, there if your Lordship finds anything, Lordship will cancel my case. My lord, in 2 earlier cases, I was arrested for some inconsistencies in revenue record. In both the cases, the Honorable Court has granted me bail.
No, let me go through the
No, my lord,
case.
my humble submission is, because the odds are against me, my lord, all the end of the day, my lord, the question of my liberty. Lordship will kindly consider that. Friday, if your Lordship finds any material in the CD, Lordship will cancel it. Lordship will recall the order, my lord. My lord, where do I go, my lord? I am a suspended man. How do I influence anything? The record could not be located, not because of my fault. My lord, in some cases, we find, my lord, some special arguments are advanced. In some cases, they don't even oppose, my lord. I can give 6, 7 instances just now.
Heard, Mr. K. N. Chaudhary.
Where chief minister's petitions are moved, nobody opposes.
Learned.
This is not relevant, Lordship.
This is relevant. This is relevant.
Lordship, for getting that interim order, this irrelevant submission may not be.
What is relevant, your time will say.
Learned Senior Counsel assisted by Mr. T. Deuri, Learned Counsel for the petitioner. Also heard Mr. P.P. Dotto, Learned Additional Special Public Prosecutor. Additional Special Public Prosecutor, CM Vigilance Cell. This application under section 482 of BNSS has been filed by the petitioner, namely Shri Laksha Jyoti Das, who is apprehending his arrest in connection with Vigilance Police Station case number 19/2025 under section 120B/467/468/471/198 of Indian Penal Code, read with section 13 within bracket 1 within bracket A/13 within bracket 2 and 12 of Prevention of Corruption Act 1988. The gist of acquisition against the present petitioner is mainly that he has issued a certificate for economically weaker section to one Shri Izaz Yusuf Ahmed, flouting the requisite norms as provided in the guidelines issued by the government of Assam. Stop. Learned Counsel, Senior Counsel for the petitioner has submitted that the alleged EWS certificate was issued by the petitioner in his capacity as circle officer of the Dispute Revenue Circle 5 years back on 27/2/2020. It is further submitted that the said EWS certificate was issued by the petitioner on the basis of original documents produced by the applicant, as well as on the basis of the report of the Lat Mandal, which was submitted after field verification in the said case. Learned Senior Counsel for the petitioner has further submitted that after initiation of after any preliminary inquiry was done,
No, based on
that after registration of this case, it has that it is apparent from the FIR itself that the original documents submitted by the applicant were found missing. Where it is mentioned?
page 6, page 20, because during relocation of the office,
Para?
para 6 of the FIR, page 20, on top.
Were found missing. And it was reportedly due to the relocation of the office during construction of CDC office building. Learned Counsel for the petitioner has further submitted that the petitioner has already been kept under suspension since 1/2/2024, and therefore he does not have any control over the official business in the office of the Dispute Revenue Circle. Office of the Circle Officer of the Dispute Revenue Circle anymore. He further submits that the petitioner is ready to cooperate in the investigation. When will you produce case diary?
I can produce tomorrow also. Lordship.
Day after tomorrow.
Day after tomorrow. Lordship.
Stop. On the other hand, learned additional special public prosecutor has submitted that there are sufficient incriminating material against the petitioner, and he is ready to produce the case diary as early as possible. And considering the nature of the accusation leveled against the petitioner, he opposes the grant of any interim protection. Stop. Let the case diary be called for. Let this matter be listed on 4th of September.
Okay.
However, in the meanwhile, considering the submissions made by Learned Senior Counsel for the petitioner, if the petitioner is arrested before arrival of the case diary, he shall be granted interim bail of rupees 30,000 with one surety of like amount, subject to the.
Lordship, if Lordship grant the interim, then no purpose for producing case diary day after tomorrow.
Why no purpose?
Already Lordship granted, then another long.
It is granted in interim only. If you can justify
Lordship.
it will be vacated.
Till Friday, Lordship, there will be nothing would be happen, Lordship. I assured Lordship. So Lordship may not pass any order. Lordship, I'll produce the case diary invariably on Friday.
How can my
Because
learned
Lordship
friend?
says that case, Lordship. Because there is a great ramification in this, Lordship. As Circle officer is floating the norms by giving.
No, you produce the case diary, we will verify it,
Yes.
whether detention is necessary or not. He shall be granted interim bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions, number 1 and number 2. List accordingly.
Deeply.
Item 54.
None has appeared for the petitioner on call. CD is there.
Yes.
It is a POXO case.
POXO is there also. 8 of.
Who is the counsel? Let this matter be listed again on Monday. Monday is 8th. And, Mr. B. Sharma Lanin, additional public prosecutor, is present. You are appearing for heard also Miss B. Chaudhary appearing on behalf of Mr. K. and Haloy, London Council, for respondent number 2, who submits that when have you appeared? Oh, okay. She also submits that the petitioner has not yet submitted the copy of the bail application as was directed by this court by order dated 19/8/2025. The petitioner is again directed to furnish the copies of bail application, along with the annexures to the learned counsel for respondent number 2. Let this matter be listed again on Mondays, 8th of September.
Item 55.
AD has not been received.
So in this case, I have been instructed that charge sheet has been filed. So your lordship may call.
CD is there.
No, lordship, CD not received. Based on the submission, lordship will dispose.
What is the matter?
It's a POXO, your lordship. And we have already filed the AB. Our AB was rejected at the trial court. So well, it's if TCR may be called for.
No, you appear before the trial court now. Charge sheet has been filed.
Yes.
You will receive summons.
Yes, your lordship.
On receipt of summons, you appear before the trial court, and you may.
So generally, what's happened is that once I appear before the trial court, they directly send me to the custody. That's the procedure.
No, that is not the procedure. Had Mr. What is the name? D.K. Agarwal, learned counsel for the petitioners. Also had Mr. B. Sharma, learned additional public prosecutor, as well as Mr. A. Bordbhuya appearing on behalf of Mr. A. Laskar, learned counsel. B. A. Laskar. T for
T for
Tiger.
Yes.
Telangana T.
T. A. Laskar, learned counsel for respondent number 2 and 3. Learned counsel for the petitioner has submitted that petitioner has come to know that the charge sheet has already been filed in this case. Stop. In view of the submissions made by learned counsel for the petitioner, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
I'm sorry, Lordship, 26 and 27 are different matters.
It is CID. CID matter.
27 is different.
26 to Amar, right? CID for.
Yes, so regarding 26, Lordship, this matter has been dealt with by KK Parasar, Lordship. He has to leave suddenly, Lordship, due to some emergency.
So we'll take it.
Tomorrow, also, Lordship, we are, okay.
27 and 26 are connected matters.
No, Lordship.
No.
26 is different, 27 is different.
Okay.
Tomorrow, tomorrow.
Tomorrow we'll take it. Heard Ms. T. Som, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that this matter has been dealt with by another additional public prosecutor named the P.S. Locker, KK Parashar, who had to leave the court due to some urgency, and therefore he prays for listing this matter tomorrow. The prayer is allowed. List this matter tomorrow, that is on 3rd of September 2024. No. If urgency is there, let it be at 10:30. Why 2 p.m.? Let it come in. Let us see when it get listed. 27?
It is.
I think 27.
None has appeared for the petitioner on call. Ms. N. Das, learned additional public prosecutor, submits that the case diary is available. Let this matter be listed at the date of 10th of September.
Ready to be written.
This case diary shall be retained till next day.
Taped on
About
record
Bilal,
number 1,
28,
record number 2,
25.
my lord.
Yes.
Taped on respondent 2 was taken from through PP, my lord. PP also is involved, my lord.
Yes, whether it has been served
My
or
lord,
not.
the office note doesn't say that it has been served, my lord. Initially, it was taken by HR code, thereafter, again steps have been taken by.
You take information. Which police station?
My lord, this Bozali, my lord. Bozali, Polo Patpatsal.
When you can take? During lunch.
Tomorrow, Lordship.
So we'll post it next week, my lord.
Tomorrow it. Date the open. One. Day after tomorrow. Heard Mr. S. Bora, learned counsel for the petitioner, also heard Ms. N. Das, learned additional public prosecutor, who seeks 2 days' time to get information regarding the fate of notice issued to respondent number 2. The prayer is allowed. Let this matter be listed again on 4th of September.
32.
None has appeared for the petitioner on call. Ms. N. Das, learned additional public prosecutor, is present. Let this matter be listed on at the date of 9th of September.
Maybe losses, one of the actual losses in reason in just perusing this application, my lord. The petitioner is a candidate in the BTC elections, my lord. By your lordship's kind order, he has been able to file nomination today. Now, my lord, the another major barrier, my lord, the thing is he is contesting. And he has filed the nomination all right. But election date is my lord, so notification. Is on 22nd of September.
No, but you have not prayed for. You prayed for interim bail only for.
Well, 22nd of September is the September is the date of poll. So may I pray, my lord, that order of your lordship's interim order, which is
Where is the proof that you have filed nomination paper?
today. Today is the last day of filing nomination.
You have filed.
Up to 3.
You will be given some acknowledgement.
Yes.
At the time you submit that acknowledgement.
Yes.
And then we will consider.
Malik, then I'll be placing it at 2, my lord. I think he has filed. Up to 3 o'clock is the time today. Yeah, I have Malik on affidavit this step 2.
Okay. Yes, Ms. Das. Let them produce the record of filing nomination. In the second half, we'll take it.
The 2, my lord. The item 46, my lord. We in the queue in last time is up to 3. So let the matter be taken up after half an hour.
Okay.
He is in the third queue, third number queue.
Okay, we'll take it up after some time.
After 2:30.
3
Yes, yes.
at 3.
3 is the last. All right.
Item 6 at 2, item 15.
Mr. Agarwal,
Lordship,
you did not appear personally today.
Lordship, I injured my knee yesterday, so a little bit of medical issues were there, but I will like to address my Lordship to satisfaction through VC Lordship. I will not take much of a time, Lordship.
Mr. Sonar, how much time will it take?
I'll take much time, my lord. So, few relevant facts, my lord, I will make submission. Then
Because what I anticipate that hearing would be long.
Lordship, it will be long because we have 4 matters and
Now
each involves fraud on court.
Yes, listen to me. And my screen is placed on my right hand side. So I have to keep my neck bending throughout the hearing.
Oh,
it is not very convenient. Therefore, I gave you time.
Lordship, in that event, we can take item number 10 today because in the rest of the 3 items, Mr. Sonar has completed his arguments and only I need to reply, Lordship.
No, I have not heard Mr. Sonar.
my lord, so far item number 28, which is the order, my lord. This only last occasion, my lord, I made a submission only on the law point, my lord, that section 362 bar of the CRPC, which prohibits the review of the, my lord, order whereby the bail was granted, my lord. Because there is a, my lord, difference, my lord, cancellation of both bail by the same court or with the appeal, my lord. So here is the case, my lord. Then one law, my lord, I placed, my lord, one judgment. Then reply was supposed to be given by the petitioner.
No. I intend to hear it, but not through VC. When you can appear in person.
Lordship, coming week, any day other than 11th, Lordship. Any day even.
When you can come, Mr. Sonar.
My lord, I have some difficulty, my lord, this.
No, you suggested it. I will fix it by mutual consent.
After vacation, my lord. October.
You suggested it. We'll fix it at
27th, my lord.
20 27. Oh, is it agreeable?
Lordship, I place my
Not-
humble apologies, Lordship. I have been in this case where bails are being enjoyed by fraud on court. So any moment they enjoy a further freedom is a bolt on the face of this court, Lordship.
No,
Then that is why even not being sick, well, I have been through VC, Lordship. Kindly, Lordship can take item number 15, the rest 3, Lordship, they can appear through VC. Only I need to address the court.
Item number. Item number?
10, my lord. 15. My lord, 3 grounds, my lord, I am challenging my lord, this item number 15, my lord, 482,
Item number 15 for final disposal.
my lord.
How much time will you take?
It won't take much time, my lord.
How much approximately?
15.
And how much time will you take, Mr. Agarwal?
Lordship, 5 minutes less than what Mr. Sonar takes.
Okay. So, okay, let me hear it.
Yes, sir.
Not more than half an hour to
My-
in total, both of you.
Basically, my lord, this 482 application, my
Joke.
lord, CRPC, my lord, is challenging here the impugn order dated 2/6/2023, my lord, passed by the learned CGM Kamru, whereby the, my lord, cognizance of the this police case number 878/2023 has been taken, and my lord, someone was issued against the accused person. Basically, the ground of challenge, my lord, why this order is bad, my lord.
Where is the impugn order?
Impugn order, my lord, will find at page number 84, my lord.
I'm sorry for interrupting, Lordship. The order which they are challenging, Lordship, the records are not before the Lordship.
In the possibly it is shown.
And
here is available.
the trial court records are there.
Trial court records of Lotasil, no?
Yes.
That is not on record, Lordship, if I'm not wrong. Yeah, but last time I checked, it was not there.
What is the case number?
Latasil,
Police PRC case number 878/2023, my lord.
GR case number?
PRC given only.
this is
GR
probably
not
Lordship
given,
pertaining to Dibrugarh PSS. The records that are before your Lordship, this is pertaining to Dibrugarh PSS.
Yes, it is Dibrugarh
Yes,
PSS.
Latasil is not before your Lordship, because on the last occasion, I saw also office note Lordship, which also suggests that the records is not.
Then records would be necessary. Or whether it can be heard without records.
Can be heard, I think, my lord, this impugn order certified copy I have enclosed, my lord.
What ground you are taking?
My lord, first ground, my lord. First ground, my lord, there is a bar under section 195 CRPC, my lord, which bars, my lord, taking cognizance of the such nature of the case, my lord. Because the FIR,
You have annexed the FIR
yes, my lord, I have annexed the FIR, my lord.
and statement of witnesses.
There is no statement of witnesses, my lord. In the charge sheet, my lord, second ground, my lord, no prima facie case, my lord. Now, there is no FSL report showing that any such alleged forgery was done, my lord. So, and there is no FSL as well as, my lord, no corroborating any evidence, my lord. So, there is no at all prima facie case, my lord. Third ground, my lord. My lord, kindly turn to page number 84, my lord. The impugn order, my lord. 84, my lord.
Mr. Sharma, we are hearing this matter. If I feel that records would be
It
necessary,
will be necessary, Lordship, in my humble submission, Lordship, because they are stating that the FSL report is not available and so on, Lordship. We have to check. the records,
Verify.
Lordship. We have to verify.
okay, then records would be necessary. It was not called for earlier.
No, it was called for, Lordship. Lordship will peruse one office note where it states that the records has not been received.
Which is the court?
CGM
CGM
Kamrup, my
court,
lord.
Kamrup Metro.
Lordship, records were received, if my lords can pursue the order dated 19/9/24, Lordship.
No, we have records, but of Dibrugarh court.
Oh, I apologize, Lordship. Lordship, since Mr. Sonar has already made 2 points of his submission, kindly, if my lords allow him to make the rest of his submissions, I will challenge this petition on the maintainability ground, Lordship. And then the records and much more will be required, Lordship. Please allow us, Lordship.
No, we will not go in piecemeal manner.
Lordship.
Heard Mr. R. Sonar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr. M.K. Agarwal.
Lordship.
M.K. Agarwal, respondent number 2, appearing in person through video conferencing. Learned additional public prosecutor has pointed out that in this case, the scan copy of the records of GR case number, scan copy of the records of PRC case number 878/2023 arising out of Latasil PS case number 326/2019 have not yet been received. Stop. He submits that perusal of the records would be necessary for consideration of the instant criminal petition. Stop. This court is also of the view that the records of PRC case number 878/2023 as well as the scan copy of the case diary of Latasil PS case number 326/2019 would be necessary. Hence, issue reminder for the same. Registry to issue reminder to the trial court for sending the aforesaid scan copy.
My lord, here in this case, my lord, earlier argument was complete, my lord. Then, my lord, this matter was reserved for judgment. But later on, my lord, due to transfer of
Then without record, it was heard.
my lord, that's why, my lord. Then Justice Pathak, my lord. Then upon his transfer, then the matter was released, my lord. Now earlier, my lord, there was a stay order, my lord,
Stay of-
suspending the proceeding because I am challenging here the cognizance and issue of the summon. So unless it is not, my lord, stay, then, my lord, again another parallel trial will be proceeding there, and it's a prima facie case, my lord. This is
No,
my
you will receive fresh summons.
lord, that's why, my lord.
You will receive fresh summons if stay is vacated.
Not vacated, my lord.
It has lapsed.
Let's, my lord, it was released, my lord. Thereafter, my lord, that's why my prayer, my lord, this stay may be, my lord, restored, my lord. Because, my lord, here, my lord, kindly see the impugn order 84, my lord.
No, if you receive fresh summons from the trial court, you may approach this court. We will, because it will not automatically start. You will again receive summons. So
that is my apprehension, my lord.
therefore we are not going into the matter of stay now. We will, when it can be fixed. Mr. Hassan, you are also there.
29 and 30 million.
Okay, that, when you can,
October, my lord, 27, my lord, after vacation.
okay, but there will be no stay.
Otherwise, my lord, this is a case, my lord, if sees the impugn order.
Okay, let this, 27 October.
Lordship, October is too far away, Lordship. And again, a 2 months gap, Lordship.
No, then this is Mr. Sonar's case. So if stay is not there, it will not affect your interest.
Lordship, a peculiar instance has risen. A stay was granted ex parte without hearing us. The
No,
stay has lapsed.
No, we are not going into that question. I am not granting stay now.
Lordship can kindly fix it anytime during this month, Lordship, to your Lordship's convenience. October is too far away, Lordship.
No, we have to,
I don't have any other, my lord, this.
I am seeking your convenience. That does not mean that it has to be fixed as per your convenience only.
Lordship, this petition itself is not maintainable.
Date due, October 28th October. let this matter be listed on 28th October. And other matters, 29,
Connected matter.
not, it has to be listed along with this case.
As petitioner, if he wants, let him.
Lordship, Mr. Sonar's case can be tagged with this, but the other two can be separated, Lordship, in which the Honorable Learned Counsel, Mr. Hassan, is appearing, Lordship.
They are not connected matters.
No, all are different, Lordship.
Item number, Kiman.
29 and 30 can come up together, Lordship.
28, my lord, it can be taken together with this criminal.
Item number 28. 28, 29, 30. All shall be tagged together. On 28th of October. List accordingly.
Lordship.
44.
Yes.
My lord, I'll just hand over a small piece of paper, my lord.
Who is on your other side?
My lord, I am sick of this, my lord. My lord, it is reflected in the post list 2 days back at 2 p.m., my lord. This is my case, my lord.
Kinam Putul. NCB Council of Punko. Any of the NCB Council.
Even I have sent, in the meantime, I'll just deliver it.
Yes.
My lord, initially in this, my lord, this is my case. If your lordship goes through this, initially charge sheet was filed on 3/2/2021 against 4 persons. These are the name of the 4 persons. Only one thing I skipped, I could not mention here. 707 kg of ganja was recovered from this accused number 1, 2, and 3.
Who are you?
All the above named accused are granted.
Who are you?
My lord, I am a.
You are not amongst these 4.
No, my lord. In the year 2021, charge sheet was filed against 4 persons. All of them are on bail. Now, supplementary charge sheet is filed after 3 years on 16/2/2024 with a prayer to show the present petitioner arrested. Now, my lord, the present petitioner was in custody in the state of Bihar in connection with some other case, not NDPS. So a prayer was made after 3 years to show him arrested. On 20/2/2024, court allowed the prayer for shown him arrested. Now, my lord, while showing him arrested in connection with the present case, no ground of arrest whatsoever was communicated to the petitioner. He is in custody since last 1 year, 6 months, and 13 days. Point number 7, nothing whatsoever was recovered from him, and he was arrested merely on the basis of the statement of co-accused recorded under section 67. And
What was the accusation against you?
Accusation against me, they say that I had a connection with these people, my lord, with this who were arrested. Now, after 3 years, they have come to know about this. Now, out of 8 witnesses, only 3 witnesses has been examined, and the last witness was examined on 30/11/2023, that is before the arrest of the present petitioner. Now, next date of evidence is 9/9/2025, and I'll be making an application for recalling of PW 123 for cross-examination on behalf of the present petitioner. So, not even a single witness has been completely examined in this case. Prolonged incarceration, Vehan Kumar squarely applicable. Even Tufan Singh will come into it. That's my case, my lord.
This is your first bail application.
First bail application.
Yes.
Lordship, may come to page number 48, Lordship. Role of the petitioner, Lordship. Lordship, 4th para.
Yes.
May I read, Lordship?
Yes.
That notice under section 67 issued the two bids under Rai so and so on 11/9/2020 to appear at NCB Guwahati office to record statement on 30/9/2020, but he did not appear on due date. Another notice under section 67 issued to Virchandra Rai on 5/10/2020 to appear at NCB Guwahati office to record statement on 2/11/2020, but he did not appear on due date. One letter received from Tej Narayan Roy, advocate, in which it was stated that Virchandra Rai is unable to come to Guwahati to record statement due to poor financial condition and COVID-19 problem, and also requested to allot next date to record statement or investigate at his hometown. Note, original letter from Tej Narayan Roy was submitted in the final complaint. That another letter along with notice under section 67 sent to Virchandra Rai on 11/11/2020 to appear at NCB Guwahati office on 2/12/2020 to record statement, but he did not appear at NCB Guwahati office on due date. One letter from notary Samastipur Govt of Bihar received on behalf of Virchandra Rai by mentioning his inability to come Guwahati to record statement. After that, Lordship, we have filed our objection, Lordship. In objection, it is may not be on record, Lordship. Okay. I'm reading from the objection. I will supply.
It is on record, my lord.
Lordship,
I've checked, my lord.
In page number 68 of our objection, Lordship.
Where is the objection?
The file where that bail petition file. My junior have seen it.
No. Yes, you may read.
Lordship, that in January 2024, one letter received from Musafir Thana, Samastipur, Bihar.
No, in the addition supplementary charge sheet which you have filed, you filed a supplementary charge sheet.
I have annexed it, my lord. I do not know, my lord, why she is saying.
Lordship, I'm reading from the paragraph. Lordship.
Page number 44 is the supplementary charge.
Mr. Bishwas, you take your seat. You, in the supplementary charge sheet, what allegation was made against the petitioner? Because what you have shown to me is that he has only disobeyed section 67 notice. But what was the accusation? What was the allegation against the petitioner?
He is the receiver of the contraband, Lordship. Sufficient materials are there, Lordship.
Intended receiver.
Receiver.
Because before he receives, the contraband was seized.
Lordship, sufficient materials or call details are there. Contraband recovered from the Tarun Rai Sujit, Lordship. And call details are there, Lordship.
Or written objection is not there. You have a copy of that. No, Miss Deka, his main plea are that at the time of showing him in the arrest in this case, no grounds of arrest was communicated. Second is that he has been arrested mainly on the basis of statement of co-accused without any other material. You address these questions only.
Section 50 notice, 47 notice was not supplied to him because he was shown arrested here, Lordship.
Then how will he know in which case he has been arrested?
I agree, Lordship, it is not served to him, Lordship. He was shown arrested, Lordship, in this case. Because he is involved in another two cases, Lordship. He is a repeated offender, Lordship. This is my submission, Lordship. We have clearly mentioned in our objection, Lordship, para number 4, 5, Lordship, 5, 6, 789. Lordship clearly mentioned Lordship everything. He was shown arrested on 20 to 24, Lordship. And Lordship, why regarding delay? Lordship, that trial has been delayed only because of him. Because for 1.5 years, Lordship, trial is at the appearance stage, Lordship. And recently, Lordship, on 15/7/25, bail was rejected in the trial court, Lordship. I have received this instruction, Lordship.
Where is the rejection order?
They have not annexed, Lordship. I
That
have
is the
received
lower
instruction,
court
Lordship.
below, my lord, not high.
In high, not high court, in trial court, Lordship.
Where is the additional supplementary affidavit, supplementary charge sheet, page number?
Page number 50, not 50, 44. My lord, before the supplementary charge sheet, my lord, may I just take your lordship to page number just to show at, my lord, may kindly come to the initial charge sheet at page 1616. My lord is there at page 16.
Yes.
My lord will see if they were so confident that there are material against me, why, when the initial charge sheet was filed, my name does not figure out in the array of parties, not even as an absconder. It is only 4 listed witnesses, accused persons. One, page 16 and 16A, there are 4 number of witnesses. After 3 years, they rose from their slumber and they filed this additional charge sheet at page number 44. And let us see, my lord, what they write. Page 45 is the charge sheet, that some letters were written to me, and the other case which they are saying, my lord, I am already on bail. I have annexed the bail order also. That is not an NDPS case. Now, para number 8, all volunteer statement of Virchand, volunteer statement of Virchand. Then they mention about some mobile number at para 10. Then again, para 11, accused admitted in the sense, again, his confession under 67, inadmissible. Then para 12, they come to a conclusion that he is the receiver, intended receiver, the way your lordship has put it. And page 48 is from where they have copied their additional affidavit. These are the same line that notice under 67 was issued. Page 48, they have just taken this, and after 1.5 months of issuing notice from this court in this bail application, they filed their objection, just replicating this, page 48. Word by word, preposition, conjunction, all same. That 67 notice was issued, it is. But during COVID time, nobody will take a risk. And if they have sent a 67 notice, and if there were cogent material against him, and if they are saying that he is trying to evade arrest, what force on earth prevented them for making me as an accused person in the first charge sheet? I would have taken my legal recourse then. And all the persons who have been arrested in the first charge sheet are already enlarged on bail by different courts, my lord. And most vital thing is that, my lord, no notice whatsoever was served.
Yes, anything?
So my only submission, delay took place only for him, lordship. Only for him, and he is a repeated offender.
Okay.
Just 10 seconds rebuttal, my lord. Probably she is getting confused. I am not on delay from the date when the initial charge sheet was filed. I am on from the date when he was arrested. So he is already in custody from where the delay factor. I am not on, probably she is getting confused. She thought the delay, I am not counting the delay from 2021. I am counting the delay from 20.
Heard Mr. M. Bishwas, learned counsel for the petitioner. Also heard Ms. M. Deka, learned counsel for NCB. This application for bail under section 483 of BNSS has been filed by the petitioner Virchand Ray alias Bir Chandra, alias Veer Chandra Ray, who has been detained behind the bars since 2024, within bracket for more than 1 year, 6 months, in connection with NDPS case number 8/2021, corresponding to NCB crime number 12/2020 under section 20B2C/29 of the NDPS Act 1985, pending before the Court of Learned Chief Judicial Learned Session Judge Kamrup at Amingo. The gist of accusation in this case is that on when the
Para 3, page 3, para 3, page 3, the gist of the accusation I have written, para 3. page-
when the first charge complaint was filed,
First complaint was filed on 3rd of February 2021.
gist of the accusation is that on 3rd February 2021, the Narcotics Control Bureau, represented by one Kaushik Sarkar, intelligence officer, Kumar Guwahati Journal Unit, had lodged a complaint before we complained, which was registered as a NDPS case number. NDPS case number
NDPS case number 8/2021.
8/2021, wherein under section 20B2C/29 of the NDPS Act, wherein 4 accused persons were named, namely Tarun Kumar, number 2, Pramad Roy, number 3, Sujit Kumar, and Baiju Thakur. It was alleged in the complaint that about what is the weight of the contraband?
7 kg of
About 707 kg of suspected ganja was recovered from the possession of the petitioners, the accused number 1, 2, and 3 named in the FIR. Stop. Later on, a supplementary charge sheet was filed after about 3 years on 16/2/2024, showing the petitioner as an accused in connection with the said case. The petitioner was at that point of time was detained in connection with another case, that is Mufassal PS case number 536/2023, where in the state of Bihar, and a prayer was made to show the present petitioner arrested in connection with the
NDPS case number 8 of the.
in connection with NDPS case number 8/2021, which was allowed by this Court of Learned Special Judge Kamrup, and accordingly on 20/2/2024, when you were shown as arrested?
On 2024, 20th of February, 2024.
On 20th of February 2024, the petitioner was shown arrested in the NDPS case number 8/2021. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR. He submits that when the petitioner was detained behind the bars in connection with Mufassal PS case number 536/2023, and when he was shown arrested in the case number NDPS, in the NDPS case number 8/2021, no grounds of arrest, no grounds of arresting him in the aforesaid case were communicated to him. He therefore stopped. Learned counsel for the petitioner therefore submits that there has been a clear violation of the statutory mandate of the statutory mandate as provided under Section 47 of the NDPS Act, as well as Section 47 of the BNSS, as well as Section 52 of the NDPS Act, and Article 22(1) of the Constitution of India has been violated. He submits that the petitioner is entitled to get bail on that ground only. Stop. Learned counsel for the petitioner further submits that nothing was recovered from the present petitioner in this case, and he has been implicated in the aforesaid case only on the basis of the statement of the co-accused recorded under Section 67 of the NDPS Act. Learned counsel for the petitioner submits that such statement of co-accused are inadmissible as evidence in the NDPS case number 8/2021 against the present petitioner, in view of the observation of the Apex Court in the case of Tufan Singh versus State of Tamil Nadu, reported in 2021 4 SCC 1. Learned counsel for the petitioner has further submitted that there are 8 prosecution witnesses listed in the complaint petition, and 3 of them were already examined before filing of the supplementary charge sheet against the present petition. Hence, the witnesses who were already examined in this case would also be required to be called back for the purpose of cross-examination by the present petitioner. And thus, there is unlikelihood of culmination of the trial at the earliest. He further submits that from the date of his showing arrested in the aforesaid case, more than 1 year, 6 months have lapsed, and the trial has not progressed fairly. And therefore, the petitioner is also entitled to get bail on the ground of prolonged incarceration. On the other hand, learned counsel for NCB, Ms. M. Deka, has submitted that the petitioner is a habitual offender and there are other criminal cases pending against him. She also submits that the petitioner was intended receiver of the seized contraband, and same is, and to that effect, there are sufficient incriminating materials on record. She also submits that all data records of the telephonic conversation between the petitioner and other co-accused shows that the petitioner was in constant touch with the other co-accused of the case on various occasions. She also submits that the trial got delayed because of non-cooperation on the part of the petitioner. She submits that on several occasions, notice under section 67 of the NDPS Act were issued to the petitioner. However, on one or other pretext, he failed to appear before the appear before the officials of NCB, which resulted in delay in culmination of the trial of the said case. She therefore opposes grant of bail to the present petitioner. I have considered the submissions made by learned counsel for both sides. Apart from the fact that since the date of showing the petitioner arrested in the NDPS case number 8/2021, more than 1 year, 6 months have lapsed. However, when the last witness was examined?
30/11/2023.
Before the last. However, the trial has not progressed, and it appears from record that the last witness was examined on 30/11/2023. That is even before when the petitioner was shown arrested in this case. Stop. Moreover, it is admitted even by learned counsel of NCB that at the time of showing him arrest, no grounds of arrest were communicated to the petitioner. This, comma, in the considered opinion of this court, clear violation of the constitutional mandate as provided under Article 21 22 within bracket 1 of the Constitution of India, as well as Section 47 of the BNSS and Section 52 of the NDPS Act, as it is the requirement, both statutory as well as constitutional, that as soon as a person is arrested in connection with a case, he has to be communicated with the grounds of arrest, grounds of such arrest. However, in the instant case, same has not been done, and therefore there is infringement of the fundamental rights of the petitioner guaranteed under Article 22(1) of the Constitution of India. And on that count only, he is entitled to get bail. Stop. as the petitioner is found entitled to get bail on the aforesaid grounds, this court does not intend to discuss the other grounds taken by the petitioner while seeking his bail. Stop. For the aforesaid reasons, the petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned Special Judge Kamrup with following conditions, trial conditions. This bail application is hereby disposed of.
I'm deeply aware.
In 43, Lordship, I have small prayer. My senior will appear here in this case, Lordship.
In which case?
In this case, Lordship.
Yesterday, this case came up before a lordship.
They are in,
Only-
it's in court number 18, Lordship. You will come and do the matter.
Only the point is that, my lord, whether the tracking report is available with them. The notice served upon the.
Okay, let us wait for when he will appear.
We have received only one document, Lordship. Yesterday, I went to the additional district session just now 5 to check the record, Lordship. That intimation letter was there, Lordship. But yes, it is true. It is specifically
was
not
there.
found, Lordship. It was there, Lordship. I went to the session judge, Lordship. I checked the record, Lordship. Intimation
47.
47 letter was there, but intimation letter was also there. But Lordship, specifically the sign was not there, Lordship, but letter was there, Lordship. I checked the record, Lordship.
That's the issue, my lord. 48, they say the 48 they have intimated, whether I have received or not. I have not received. That is what-
So my Lordship, my senior will come and.
Let him come.
Well.
We'll take up other matter.
45.
May please not. Actually, this is the intermediate quantity 59 days till today, custody period. And the opium was 147 gram and commercial quantity is 2.5 kg.
2.5.
kg,
How much was found?
147 gram.
Okay.
Yeah, Lordship, 57 days today, and I tried to contact the IO, Lordship, if charge sheet has been submitted or not, Lordship. Unfortunately, I could not contact the IO regarding whether charge sheet has been filed or not.
We'll assume that it is not filed because no information is there.
I tried, Lordship.
Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Sorry. This application for bail under section 483 of BNSS has been filed by the petitioner, namely Sushil Kumar Singh, alias Bhiram Ram. Namely Vikas Kumar Singh,
alias Shyamlal Bishnoi.
alias Shamlal Bishnoi, who has been detained behind the bars since 6/7/2025 in connection with DFU PS case number 57/2025 under section 17 within bracket small b of the NDPS Act 1985. The gist of accusation in this case is that on 5/7/2025, one Gautam Kumar Nath, SI of police, had lodged an FIR before the officer in charge of DFU police station, inter alia, alleging that on receipt of an information through the source, through reliable sources, inter alia, stating that a person has visited District Jail Karbi Anglong as a visitor and had supplied prohibited drugs to one of the inmate of the district jail, Karbi Anglong. Accordingly, a team of police was constituted and they rushed to the district jail Karbi Anglong and no, Uparot, a person will visit instead of has visited, will visit to supply so and so. Now, accordingly, when the team was waiting outside the district jail Karbi Anglong, the present petitioner was found coming out of an auto rickshaw. And when a search was made, from where it was found,
Position of 147 grams.
search was made. 147 grams of suspected opium was found in a plastic herbal Colgate tube. Stop. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 57 days. No, in the manner in which the offense is committed. What is your submission apart from the period of detention? On merits.
This 147 gram, including plastic tube, and it will come to a small quantity, not because including the plastic tube.
How much is the small quantity?
25. Plastic tube, including plastic tube, is 147 gram.
क्या लिखा? 57 days, and considering the
59 days, I think, Lordship, the 6th of
period
July.
of detention.
6th of July, it will be in July, it will be 26 days. And then August is 31 days, in a year, 2 days. 32 and
You have not used age calculator.
one day can be reduced, but 58 days.
58 days.
58 days. 58 days. And also considering the fact that the seized contraband in this case is of intermediate quantity, he prays for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has submitted that the case diary is not available. He also submits that he tried to contact the investigating officer over telephone, but in vain. Stop.
So the listener is from Rajasthan.
Stop. Okay. I have considered the submission made by learned counsel for both sides and have gone through the materials available on record. It appears that the contraband seized in this case is of intermediate quantity, and the petitioner has been detained behind the bars for last 58 days. Therefore, considering the period of detention, as well as quantity of contraband seized in this case, comma, this court is of considered opinion that further custodial detention of the petitioner may not be necessary for fair completion of the investigation of the DFOPS case number 57/2025. Accordingly, the above named petitioner is allowed to, what is the assurance that you will appear?
I promise I will appear. Local surety can be informed.
Local surety.
The
My present residence in Borni Hatwa.
petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount within bracket, who shall be the resident of the state of Assam with subject to the satisfaction of learned special judge Karbi Anglong Diffu with following conditions. Number 1, 2, 3, 4, 5. This bail application is accordingly disposed of.
You submit the necessary documents like.
Yes, those will be
Yes.
PAN card.
Yes. Yes.
Those will be in the conditions.
Right.
46.
You get, we'll take it up after some time. After some time, you bring a printout of the copy. You wait for some time. नहीं है. None has appeared. For the petitioner on call. It appears that Mr. S. Das was appointed as Amicus curiae in this case, and the registry was directed to furnish copies of necessary documents to the learned Amicus curiae. However, the office note does not indicate that same has been done. The registry is again directed to no. How continue opinion. It also appears that the registry has already furnished the said documents to the learned Amicus curiae. Let this matter be listed again at the date of 18th of September. Who is for the petitioner? What is to be done? Manojit, M. Bishwas is there.
Has come by order.
This is item number. Suggest what can they? We have to fix another date. None has appeared for the petitioner on call. Any interim was there? Will not extend the interim. None has appeared for the petitioner on call. Mr. Chandran, what is your initials? A. You are appearing for petitioner? Yes. What is your submission?
Kindly pass over for the time being.
Who will be appearing?
Mr. S. Biswas. He is on legs in another court.
Okay, let us wait for some time. But we don't have much time. We'll wait for some time.
Item 47.
This is offense under POCSO Act, Lordship, under section 8. And he has been behind the bar for more than 3 years. The punishment is for 5 years.
Who is appearing for the MI?
One, you should hold.
Who is you, Chaudhary?
Ujjwal Chaudhary.
No, he's not there. What is to be done?
He usually appears, Lordship. Today he is absent. Today he is absent, Lordship. Usually he appears, Lordship.
We'll fix a short date.
Lordship, what happens, already 3 years completed. And the punishment is 5 years. Half of the.
No, this has to be finally disposed of.
Since 2023, 14/11/2023, it has been pending for hearing. Long 2 years.
Either we have to change the Amicus.
So a date may kindly be fixed, or this presence may be.
Okay.
Sure.
Heard Mr. D. Borwa, learned counsel for the appellant. Also heard Mr. B. Sharma, learned additional public prosecutor. None has appeared for respondent number 2. Though name of Mr. U. Chaudhary has been shown as the legal aid counsel for respondent number 2 in the cause list. This court intends to give one chance to learned legal aid counsel to appear in this case. Hence, let this case be listed on
9th, next, before vacation, Lordship.
16.
16.
On 16.
Item 48. This is an appeal against conviction and sentence of 10 years. He was convicted under 304. And my main ground of contention is the person was a mentally unstable person during the time of trial. The trial court's order sheet will say so. In fact, I'll try to take your lordship through that first.
How much time will you take?
Maybe half an hour.
Okay. Mr. Sharma, your document is ready. We'll take up this matter. It will take 5 minutes.
Want to send to the by mail to the registry also?
Case diary is there.
No, no.
Now, what is your prayer?
My prayer is, my lord, that since the polling date is, my lord, I have given the notification of the schedule, my lord, is 22nd of September. And after the polling, he will just settle the ballot boxes in the strong room. On 24th, he will surrender. He is already in German. Today it is, I think, 23rd day.
Learned heard Mr. R.P. Sharma, learned senior counsel assisted by Ms. P. Soam, learned counsel for the applicant. Also heard Ms. N. Das, learned additional public prosecutor. This application, this interlocutory application has been filed by the petitioner, by the applicant in connection with bail application number 2699/2025, which was disposed on 28/8/2025. The petitioner was granted interim bail for a period of 3 days, that is from 1st of September till today, that is 3rd of September.
Till tomorrow, my lord.
Till tomorrow, that is 3rd of September, to enable the petitioner to file his nomination paper as a candidate in the Boroland Territorial Council elections 2025. Staff learned counsel for the petitioner has submitted that the petitioner has submitted his nomination paper for election as
A member of the legislative
member
council.
of Legislative Council against number 19. Which constituency? Suri. What is the constituency?
Surabari.
Surabari. Today. Stop. Learned Senior Counsel further submits that the date of election has been notified by the Assam State Election Commission by its notification dated 26 August 2025. And accordingly, the election will be held on 22/9/2025. And the date of counting would be 26/9/2025. And the election process would complete on 28/9/2025. The petitioner, learned counsel for the petitioner submits that unless the interim bail granted to the petitioner is extended till the completion of the election process, he would be deprived of exercising his democratic rights, and the purpose of filing nomination as a candidate would be futile. Stop. Yes.
They only take 3 days time.
I have considered the submissions made by learned counsel for both sides. Considering the fact that the petitioner has filed nomination paper, where is the order?
Order, your lordship, order, madam.
Nomination papers for election to the election as Legislative Council member. And as the date of polling has been notified, the petitioner is required to involve himself in campaigning and participate in the election process. Stop this, comma, this court is of the considered that the interim bail granted to the petitioner by order dated 28/8/2025 in bail application number 2699/25 may be extended till 28/9/2025. Accordingly, same is done. And the interim bail granted to the petitioner is accordingly extended till 28/9/2025 with the conditions mentioned in the order dated 28th, with the condition that he shall surrender before the Court of London, Chief Judicial Magistrate, Kamrup Metro. On when will you surrender?
29, 30, 29,
On
30,
29.
29, 30, both are holidays, madam. I think here it is shown holidays. Can it be on 1st October?
On 1st of
October.
October. And on his appearance, he shall be remanded to judicial custody. This interlocutory application is accordingly disposed of.
And can it be kept pending, madam, so that after surrender we can file an affidavit and save website, madam? Let it be pending, madam. Let it fix on 2nd October is the holiday, 3rd October.
Let this interlocutory application be listed again on 3rd of October.
Okay.
So as to enable the petitioner to report compliance of the said order, aforesaid
Okay.
order. Yes, Mr. Das, we have,
Third October is holiday.
yes, Mr. Som. On 13th of October. 13th October. I have fixed a date. You have received the copies,
My lord,
Mr. Das.
33, 34, my lord. Yes, I have received the copies, madam.
I have given a date.
My
On that date,
Subject to correction. Can that surrender date be 13th?
no. Surrender date shall be 31st of October.
My name may be recorded, 33, 34.
Oh, yes, 33, 34. Mr. S. Das appears. No one appeared to Katidip.
Highly open.
No, we are taking up in the midst of a hearing. We have not started. Kudu Matisi. 38. Mr. KL, you are ready? You are ready or you will seek time?
Please, whatever we have yesterday, my junior went to the trial court.
Okay,
There is a record. I'll submit lordship.
then wait. Let us decide this. You are not ready.
Can it be on 9th, next Tuesday?
9th. 9th, Parini. 16th.
16th, I have a difficulty. I will be out of town.
You suggested it.
11th then? 11th?
27th.
Monday. Hearing the 11th or 18th, my lord?
18th also.
On request of heard Mr. D.K. Bhattacharjee, learned counsel for the appellant. Also heard Ms. N. Das, learned additional public prosecutor, who seeks a short adjournment on the ground of personal difficulties. The prayer is allowed. Let this case be listed on 18th of September.
People, I will submit lordship that all the documents are available in the trial court record, including lordship tracking report is also there. Yes, it is correct, lordship, the witness signature is not there.
Tracking report is also there.
Yes, lordship, but the entire record is not signed by the trial court.
What tracking report says?
Tracking report says that it was delivered to the addressee lord.
Okay, then that is relevant.
Yes, sir. And here their contention is that we have not followed the section 36.
48.
36 and 48, because there is no signature of witnesses. In the memo. That is not, if it was seen by the learned trial court also, seen is written there, but not in all documents. In few documents.
How much is the contraband?
21.660 kg of opium.
21. What is the commercial quantity? 5 kg.
2.5 kg.
2.5 kg.
My only contention before your lordship, my lord, my learned friend has fairly submitted. They have sent the, my lord, notice to my wife, my lord. But that acknowledgement is not there.
No, but if the track consignment report shows that it was delivered.
Yes, my lord, that's why, my lord, the copies which they have supplied, my lord, that is top of the file, my lord. There your lordship will see, my lord, there is a letter to the officer in charge of the police station, my lord, of the concerned district, my lord. That is, I think, my lord, serial number 54. If the this notice ought to have been served upon the police officer in charge of the police officer to serve upon the relative of the accused. But if the letter says, my lord, it is intimated that on dated so and so NCB sees so and so grams, my lord. They only asked, my lord, the person who belonged to your jurisdiction has been arrested on so and so in connection with this case. It is further requested that your past criminal records of the above accused, if available, be kindly forwarded to this office at the earliest. My submission would be, my lord, I may not be correct also, they ought to have sent this letter, my lord, 48, which they say, my lord, to the police officer concerned, my lord, so that it could be served upon the relatives of the accused, my lord. That was not done in the instant case.
It was sent directly.
Directly. And secondly, my lord,
It was sent directly to the
wife of the petitioner.
address directly to the wife of the
Yes,
petitioner.
that was
Now-
posted through registered.
yes.
And
I agree with my lord. Now
this
the
is-
question is, if it is sent by registered post also, my lord, that acknowledgement should be there. It is not there with them or in the record, my lord, the acknowledgement.
Lordship, it is available in the record as annexure T. Yesterday, my junior went to the court and there's a bullet mark
Okay,
record.
we'll call for that.
Thank you.
Annexure T is this one. The copy here is it's annexure T লিখা আছে। It's annexure T. This is the annexure T.
Intimation letter was sent through registered post.
Which is annexure T?
My lordship will, my lord, I think my friend is also confused, but the page 62 to show. Page 62 of my petition, my lord. Page 62 of my petition, my lord. Yesterday I have marked it, my lord. Page 62, it says the list of documents which they have annexed to the charge sheet that have been filed before the court. Now, below, my lordship will see, my lord, 20 and serial number 20 and 21. 20 is the copy of intimation of arrest is attached as annexure T, T that is 02 pages, my lord, because two petitioners are there. This is T.
Where is T?
My lord, that copy here supplied, my lord. Page number 62, so last of the petition report. That acknowledgement is not there. And 21 is the copy of intimation of arrest sent to the concerned police station are attached here at annexure U. The police is U and the person concerned is T. My lord.
No, where is the track consignment?
That lordship,
Is it available? If you can say that it is available, we will call for it.
I'm not sure.
But nowadays, my lord, my friend has stated, my lord, on the last date, my lord.
Yes.
Track reports are generally available for 6
6
months,
months.
but to my, I have cleared it, my lord, it's for 3 months, my lord. Track records are available for 3 months. After that, it is gone, my lord. And my lord, my third submission, my lord, with regard to this memorandum of arrest, my lord, it was not attested by a witness, my lord. It ought to have been attested by a witness as per section 36. Section 36. It says, my lord,
So 36, 48A and
48 and 47.
47.
But my submission will be first. They have violated the memorandum of arrest, which should be in accordance with section 36 of the BNSS. And 62 of the BNSS, which said, my lord, arrest to be made strictly according to Sanhita, my lord. No arrest shall be made except in accordance with the due provision of the Sanhita or any other law for the time being in court.
Yes, Mr.
Lordship, page 91 of my objection was paragraph 35, 36. 91.
Objection.
Yes.
Paragraph 35, that the arrest memo which were handed over to Sri Manakram and Isaram, in which all the details of the case was mentioned and explained to both the accused. It was mentioned in the arrest memo that the accused has been arrested in connection with seizure of 21.660 kg of opium by the NCM Guwahati, crime number so and so, under section 8C to be read with section 18B of 29 and 29 of NDPS. The arrest memo was also explained to both the accused Manakram and Isaram, and they were informed that he will be forwarded to the competent authority within 24 hours. Then paragraph 36, that the intimation of arrest was also sent to relative of Manakram and Isaram, mentioned in the own handwriting in the acknowledgement of memorandum of arrest served to him. I have informed my wife about my arrest over mobile number so and so. In the same manner, Isaram mentioned in his own handwriting in the acknowledgement copy of memorandum of arrest served on him that I informed my wife about my arrest over telephone number so and so. Notice under section 50 of CRPC was also served to Manakram and Isaram, and which they were informed that he has been arrested in connection with NCB crime number so and so, and the case is non-available and he may submit petition for his bail. Thus, the ground for arrest was explained to both the accused Manakram and Isaram during arrest in connection with the instant case. The intimation of arrest of both the accused were also given to the concerned police station. Then paragraphs, Lordship, next paragraph, next page. Paragraph 40. The final complete charge sheet has been, the instance case has been filed within the stipulated period. If the bail granted to the accused is possibility that the accused may jump bail considering the gravity of the offense and severity of the punishment prescribed in the NDPS Act, and he may go himself involved in similar nature of cases. Then paragraph 41 is important, Lordship, that Manakram is a habitual offender as per the report received from the officer in charge of Jairana police station and Jaitrana, that Manakram was arrested in connection with the seizure of 4418 kg of poppy straw by Jairam police station, case number so and so, under section 8-1529 of NDPS Act. And what's it further? In case recent judgment, probably my learned can raise objection to that also. But Lordship, even then, Lordship, I am placing that judgment. Copy of sir.
There in the file, last.
Paragraph 20.
Which one?
That state of Karnataka versus Darshan.
Darshan's case, or the flea actress case.
Yes,
Delay, Lordship, paragraph 20.
yes, what it says.
In the present case, the High Court may, by the impugned order,
Atul. Judgment or copy.
E2 fellow doesn't need it.
Yes, para 20.
Para 20 laws.
Yes,
To 20.1.
yes,
Delay in furnishing ground of arrest cannot be itself constitute a valid ground for grant of bail. 20.1.1, the learned counsel for the respondent accused contended that the arrest was illegal as ground of arrest were not furnished immediately in writing, thereby violating Article 22(1) of the Constitution and Section 50 CRPC. Now Section 47 of Bharatiya Nyaya.
no, but a division bench of this court has,
Lordship,
Yeah.
here, because this is judgment, there are two judgments of same strength. My learned friends is relying on one judgment of MSCT versus so and so. In that case, Lordship, there was a judgment of full bench that was deferred by the two bench judge. Here, Lordship, I am placing one judgment of Bombay High Court, which says that the High Court confronted with the contrary decision of.
no, but on this case, whether Sri Darshan would be applicable or Vihan
Yes.
Kumar would be applicable,
Lordship, that is to be.
there is a division bench judgment. This court cannot go against the division bench
No,
judgment.
Lordship, here, Lordship is to consider, there are judgment of two strength bench. Two judgments of same strength, Lordship. Lordship, now,
Of the Supreme Court.
yes, Lordship.
That
Yeah.
has been considered by division
Lordship.
bench.
Because Lordship, that judgment was not placed, because Lordship, the Lordship has to see the reasoning. Which is the reasoning, the Lordship, here I am placing on this judgment. This is also a division bench of Bombay High Court, and it was
No.
offered by.
When on the question of applicability of Sri Darshan vis-a-vis Vihan Kumar has been settled by a larger bench of this court, division bench of this court, unless that is set aside or challenged, how this court can go against that?
No, Lordship, this is my submission, Lordship, may consider, may,
Okay,
Lordship, here, in the first precedent, High Court confronted it with contrary decision of the Supreme Court, emanating from benches of co-equal strength. High Court not necessarily bound to follow the decision later in point time, but must follow one which in its view was better in point of law. So Lordship, my submission. Lordship,
Where is that?
Lordship here,
Which para?
Lordship paragraph I am placing.
In which case?
This is the case decided by the division bench of Bombay High Court.
Jaydev,
Jaydev, yes, Lordship.
which para?
Lordship, I am placing. Paragraph 22, Lordship, one word. We are therefore of the view that the judgment of apex court in case of R. Vishwanathan Pillai cited supra would not be applicable in the facts of the present case. In the case of R. Vishwanathan, it was proved.
It is distinguished.
Yes, Lordship. Lordship, here the main crux of the judgment was that if there are judgment of same strength of two bench of two judgments, then Lordship, the judgment which is contains the details ground that is to be accepted by the court. There is, and if there is a judgment of three benches judgment, then Lordship, obviously three bench judgment will be applicable. When there is a judgment of two judges, then Lordship has to see the reasoning in the judgment.
Okay.
It is my embarrassment.
My last submission, my lord. Judgment of our court is binding, my lord, and the so far judgment of other high courts, my lord, that may be in persuasive in nature, my persuasive in nature.
That is correct, Lordship.
That
This
matter, nothing else.
is the rule, Lordship. But
Heard,
Lordship has
Mr.
to see the reasoning in the judgment.
Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. S.C.K.R., learned standing counsel, NCB.
My special prosecutor for NCB.
Special public prosecutor for NCB. Let this case be listed for delivery of orders on Monday, 8th of.
I'm obliged.
I will not be available on 8th or 9th.
Delivery of orders. Any of your colleague may.
Lots.
I'm obliged.
Much obliged.
Item 56. This is a simple case by way of which, my lord, I am seeking quashment of the FIR registered under section 188 of IPC and section 14 of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003. So the brief facts of the case is that the petitioner herein is in occupation of a plot of land which has not been allotted to him. In this regard, notices were issued from the authority. As per the Act of 2003, the estate officer is entrusted and empowered to issue notice to the illegal occupants. So since in the year 2015, notices were issued, and there was a direction also that if no action is taken on behalf of the petitioner himself, then the authority is at liberty to demolish the part of the building that has been constructed on the land which has not been allotted to him. So instead of demolishing the building, the DLRSO lodged an FIR before the police authority under section 188 and 14(1) of the Act of 2003. So ultimately it has.
Who lost the affair?
A DLRSO is being arrayed as respondent number 2. I have compiled all the documents in the compilation, this volume 1 spiral binding document.
Where is the FIR?
FIR, your lordship will find at page 9. Lordship has got.
Yes.
If I may read, my lord. During the course of inspection in Tawang Township area by the land management team of DC office, Tawang, it was observed that Sri Jambe Sering, so-and-so was found constructing building near Circuit House, Tawang illegally without any land allotment order whatsoever. The ADC cum District Estate Officer Tawang had issued notice under section 4(1) of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003 to Sri so-and-so, giving him an opportunity to produce papers, documents, if any, relating to land by number so-and-so dated 2015. Sri Sering was also directed to stop the construction of building and vacate the land within 7 days. No reply from Sri Jambe Sering received. In the meantime, Sri Sering submitted a representation to the Deputy Commissioner Tawang, referring to his earlier representations on dated 2/3/16, inter alia admitting that he has occupied the government land illegally since last 5 years and had requested Deputy Commissioner Tawang to consider the case for allotment. While reference to his representation dated so-and-so, the undersigned informed to Sri Sering that submission of representation do not ipso facto confer any right to anyone to illegally occupy government land and undertake construction of building thereon. And Sri Sering has also been informed that his representation cannot be considered while letter number so-and-so. Sri so-and-so has not submitted a reply to the said letter issued by the undersigned till date. Another notice was issued by the in charge ADC cum District Estate Officer Tawang under section 4(1) of Arunachal Pradesh Public Premises so-and-so Act 2003, directing Sri Sering to remove the said Kacha building within 15 days from the date of issue of the notice, failing which the said building will be evicted, dismantled, and the cost of demolition shall be borne by the building owner by number so-and-so. It has been observed that with serious concern that even after issue of the notices without bothering to reply, Sri Sering has undertaken the construction work of RCC building on the said plot of land. Further, the building under construction is adjacent to the government quarters and is touching the government quarters. As per the direction of the government wide number so-and-so 1st September 18 for allotment of any land to any individual, the minimum distance required is 4 meters. Hence, there is no scope whatsoever for consideration of the allotment of the said land in any case. In view of the fact that the following notices were issued by the ADC cum Estate Officer Tawang so-and-so, you may skip it. On 29th May 19, the notice was issued to Sri so-and-so by number so-and-so, stating that the said notice was last and final to remove and dismantle the structure within 7 days. Moreover, Sri so-and-so, in blatant violation of the law of the land, is again carried out the construction work on the said plot of land. Again, on one notice was issued to so-and-so on 2019 by District Estate Officer Tawang to remove and dismantle the structure within 7 days, failing which the said structure will be removed, dismantled at the risk and cost of sharing, but Sri so-and-so has not bothered to remove the building till date. The necessity of filing FIR is due to the fact that even after issuing of several notices by the District Estate Officer Tawang, Sri so-and-so has carried out the construction works. It is requested that the investigation may be completed and the legal action may be taken at the earliest. The details of the encroachment site will be given by Sri so-and-so Office Tawang. This is the FIR lodged by DLRSO cum DC Tawang District. So already there were notices indication by the estate officer that if I don't demolish the building on by myself, then they will demolish the building and they will evict me. But no action, they have taken no action till today. But abruptly they lodged an FIR on 14/8/2019 and under section 188, your lordship is aware that under section 195 CRPC, there is a bar to lodge an FIR under section 188. As per the act, there has to be a complaint by the public officer before the competent magistrate. So far as section 14(1) is concerned, there is a separate proceeding which should be initiated under the Act of 2003. If I may take your lordship to the Act of 2003. The lordship has got.
Yes.
Section 4, it pertains to issue of notice to oppose against order of eviction.
Yes.
But it says, if the estate officer is of the opinion that any person is in unauthorized occupation on any public premises and that he should be evicted.
Your first plea is that CRPC 195 has been not complied with.
Yes.
Instead of filing complaint, they have filed an FIR. And second?
Second is that as per the 14.1, one act is that 14.1. 14.1 proceeding will be guided by the Act of 2003. There is no provision for lodging an FIR under Section 14.1. Otherwise, it is a civil proceeding because the entire power is given to the estate officer and the deputy commissioner to take action against the wrongdoer, if any. If someone is in illegal possession of a land, they have the power to demolish the building. In fact, by the notices, if I may take your lordship to some of the notices issued by the
Now, at what stage the case is pending?
case has been charge sheeted. So it is pending before the
Charge sheeted under what?
Section 188
188 as
and 14.1 of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act.
is there any stay?
There is a stay from this honorable court.
Now, what is your challenge as regards 14.1 of 2003 Act is concerned?
Well, 14.1 is very clear. If I may take your lordship to 14.1 for a moment. If any person unlawfully occupies.
This is the penal provision.
This is the provision and the power is given to the estate officer.
Where?
Well, I'll come to that. First, 14.1. Then, if I may take your lordship to Section 19.
Yes.
It clearly says, no court shall have jurisdiction to entertain any suit or proceeding in respect of the eviction of any person who is in unauthorized occupation of any public premises, the removal of any building, structure, fixtures or goods, cattle or other animals from any public premise under Section 6, the demolition of any building or other structure made or ordered to be made under Section 7, the sealing of any erection or work of any public place under Section 8, the arrears of rent payable, etc., the recovery, etc. So it bars, Section 19 bars the court to take up any proceeding pertaining to the Act of 2003. The power is given to the estate officer and thereafter the appellate power is given to the deputy commissioner. Now, whenever a
No. Who will decide that offense has been committed under
estate officer.
Where is that? Your
14.1.
Your submission is that an accusation regarding commission of an offense under 14.1 shall not be tried in regular criminal courts.
Yes, my lord.
On what basis you are saying?
Well, 14.1, my lord.
Show
If any person, my lord, this is the complete code which governs the, my lord, offenses falls under the Act of 2003. If any person unlawfully occupies any public premises, he shall be punishable with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 2,000 rupees or with both. Provided that a person who having been lawfully in occupation of any public premises by virtue of any authority continues to be in occupation of such premises after such authority as ceased to be valid shall not be guilty of such offense. If any person who has been evicted from any premises under this act again occupies the premises without any authority for such occupation, he shall be punishable with imprisonment for a term which may extend to 1 year or with fine which may extend to 5,000.
14.1 is a penal provision.
This is the provision and the Section 19 is very clear that no court shall take cognizance of any offense.
That is not speaking about offense under 14.1.
But it says no court shall have jurisdiction to entertain any suit or proceeding, anything.
In respect of what?
In respect of this act, my lord. The 19 is a.
No, show me which clause you are emphasizing. 19 No court shall have jurisdiction to entertain any suit or proceeding in respect of which clause you are emphasizing? 1 to 6.
Well, it pertains to any matter.
No, it pertains to matter indicated in the section itself, from 1 to 6. Unless your case falls within 1 to 6.
Well, Lord, if I may take your lordship to section 3.
Section
3.
3 of the Act.
3 of the Act. Well, Lord, here nowhere the acts even suggest for a moment that the criminal court has the jurisdiction to try an offense and irregularity committed under the Act.
Is there any bar? If a special act provides for an offense and does not provide for the procedure, for which will be the court? It will be.
Well, more or less, this is in the nature of civil proceeding, because
How civil proceeding when
well,
it is
offense-
prescribing a penalty?
the offense will be committed when there is a, my lord, non-compliance of the notices or the orders issued by the estate officer. Now, the estate officer is in the charge of the entire, my lord, offense. Thereafter, the appellate provision is given to the deputy commissioner. My lord, it is not an offense under the Indian Penal Code. This is an offense under the Act of 2003, where the authorities are defined under the Act. My lord, this is an special act. This is a code in itself. The procedures are prescribed here.
Where is the procedure? Show me the procedure to try the offense.
My lord,
When an accusation has been made under 14(1), which procedure is to be followed?
well, CRPC procedure has to be followed, like in the section 107 cases by the executive magistrate, then 145, 144 proceeding by the executive magistrate. The procedures are
145 and 107 are not penal provisions,
well, these are not the penal provision,
but 14(1) is penal provision.
well, these provisions are to be strictly applied under the Act of 2003 by the estate officer. That's why the provision is clearly mentioned that no court.
So is it your submission that even if there is an accusation under 14(1), the offense shall be tried?
Well, how this
by-
equation, well, your lordship has to look at the background, how this equation has come. When the authorities themselves has the power to demolish the building, when they are not undertaking anything regarding demolition of the building, just they are sticking to their own agenda of lodging FIR, your lordship will see the malafide intention that has been culminated in lodging the FIR. Well, there are other notices where it clearly says.
No, that is not my query. You have challenged the lodging of the FIR mainly on 2 counts.
Yeah.
First of all, under section
188,
188, there is a violation of
195.
195 CRPC in not filing a complaint. That is understandable. And with regard to section 14(1), your submission is that the
Criminal court doesn't have the jurisdiction to try an offense.
because of 19(1).
Yes, and there is no provision for lodging an FIR for trying an offense under 14(1).
Okay. Though not very convincing.
Well, no, it is convincing because there is no provision for lodging an FIR for an offense under section 14(1). At best, complaint, if your lordship is suggesting, or if the act suggests, at best they can lodge an complaint before the appropriate authority, like
From where you are saying so?
Well, the act doesn't define so, but for lodging an FIR, your lordship is aware under the civil procedures or under the civil acts. This is in the nature of civil acts. Penal provision is given. Lodging of FIR is barred.
You are submitting contrary submissions on one.
But lodging of FIR is barred. So
Where?
far as section 188 concerned.
That is
And
understandable.
14(1) is concerned. For 14(1) offense, my lord, FIR is not, my lord, required to be lodged. There is no provision for
Where
lodging
is
an
the-
FIR. Well, there is no.
Okay,
If the court doesn't.
okay, I have understood. Your submission is that since 2003 Act does not provide for lodging of the FIR,
Yes.
therefore an FIR may not be lodged
Well, power has to be, my lord, assumed from the provisions of the act, my lord. If the provisions of the act is silent about the procedure, the only procedure it is subscribed, my lord, the code of criminal procedure will be applicable. But it doesn't say the estate officer or the DL or SO is empowered to lodge an FIR before the police to try an offense under section 14(1).
Okay.
When they are equipped with the power under the Act of 2003, there is no necessity and there is no, my lord, provision for lodging FIR before the police officer to get me arrested.
Okay.
And the only vengeance, my lord, my lord, the DLRs, the previous DLRSO lost the FIR on some personal agenda, because in a case, because the petitioner here is an advocate. In a case, I contested the case against him where he lost the criminal case. And out of that vengeance, he has lost the FIR, knowing it fully well that the Act of 2003 is fully equipped to solve the problem that has arisen out of the Act of 2003. There is a provision for demolition, there is a provision for eviction. Even the notice of 2015 speaks so that if you don't demolish the building, we will demolish the building at your own cost within 7 days. But they have not undertaken any demolition process. And that's how they have lost the FIR. Ultimately, it has been culminated into charge sheet. Now the case is pending before the Tawang court.
Okay. Yes.
For a moment, if I may take your lordship to the notice, first notice issued in 2015. In the compilation at page 2. The lordship has got. In
No,
compliance.
that you have already submitted.
No, this is 2015 notice, the first notice. Here the last line, it says, in claim we said before the undersigned or stop construction or evict the said land within 7 days from the date of issue of this notice, failing which necessary action will be initiated.
So
as per
your submission is basically that if you have failed to comply with the notice, the authorities should have demolished your.
Yes, well, this is the order says, the last order.
Yes.
Page 5.
No, is this your submission that
Yes.
authorities
the
should have?
fully empowered to evict like what is going on in.
But they cannot file an FIR.
They cannot file an FIR, and there is a provision if there is a disobedience under this section 195 to lodge a complaint under section 188 before the competent magistrate. And along with 14(1) also, they can if they desire, though the provision of the act doesn't say so, but if they desire, they can file a complaint, not FIR. FIR proceeding is completely different. On the basis of FIR, I may also be get arrested. So there is a apprehension of arrest at any before, of course, before filing the charge sheet.
Okay.
And the procedure is completely different in a complaint case or lordship is ever. Complaint case and the
This is your submission.
GR case. Well, the last notice, page 6, the last paragraph. Page 6, last paragraph. Now, therefore, I so and so estate officer Tawang, empowered under section 4(1). The power is given under section 4(1) of the Arunachal Pradesh Public Premises Eviction of Another Occupants at 2003. Do hereby direct you once again to remove the building materials from the government land within 7 days from the date of issue of this notice, failing which the said structure, RCC structure will be removed, dismantled by this office, and the cost of demolition shall be required from you. That was the notice in the year 2019. They themselves did not act upon their notice. Now they are framing me in an offense under section 188 and 14(1). And 14(1) offense will come. The 14(1) offense will come when there is a, if any person unlawfully occupies any public premises, he shall be punishable with a simple imprisonment for a time which may extend to 6 months or with fine which may extend to 2,000 rupees or with both. provided that a person who having been lawfully in occupation of any public premises by virtue of any authority, whether by a grant, allotment, or by way of other modes whatsoever, continues to be in occupation of such premises after such authority has ceased to be valid, shall not be guilty of such offence. But if he has applied, as per the instruction, he has applied for the allotment for one reason or the other, the allotment has not been issued, the matter is pending. And so far as the FIR lodged by the DLRSO is concerned, it is without jurisdiction. The DLRSO could not have lodged an FIR for an offence under section 14(1) when the act itself is silent. Well, this is not an FIR under section 154. There is no offence made under section 151 IPC. There is no penal offence been committed by the petitioner herein. The offence is, my lord, here under the Act of 2003, where the estate officer has been given the power to proceed with the matter as per the provisions of the Act.
Okay.
When the power has not been given to the estate officer or the DLRSO to lodge FIR, but the lodging of FIR under this aforesaid section itself is illegal. And I'm relying on the bunch of judgment I have already handed over with the paragraph numbers. This is volume 2.
Judgment. You have furnished that compilation.
We have submit the complaint again, Your Lordship.
Into compilation plan. Yes. Which judgment you are relying?
I am relying on the first judgment procedure under section 195 of CRPC.
That is not required.
Yes, my lord, this is.
Then
Taking cognizance, the procedure of taking cognizance. And
in support of your
Well,
submission that 14(1),
but 14(1) is a special act of Arunachal Pradesh.
is there any judgment?
No, my lord, I have
Okay.
not found any.
So these judgments relates to acquisition under section 188.
188, and thereafter that the Supreme Court has held that FIR can be quashed even after filing the charge sheet. In CL number 12,
Okay.
Joseph Salvaraj, then Anand Kumar Mohata, and thereafter the power of the High Court to quash.
Okay, let me hear the other side. You have any other submission?
But subject to what my learned
Yes.
says, I will reply.
Mr. Chandran. Ms. Chaudhary, you are appearing for
One, my lord.
the informant, first informant.
Lordship, here the main issue with regard to the response number 2, Lordship. Response number 2 has.
No, what is your response to the submission that
Lordship, actually.
14(1) offense?
Lordship.
Is it a cognizable offense?
Lordship, with this regard, Lordship, actually in Arunachal, what happens is that whenever a illegal construction is noticed, Lordship, the notice is being issued. And subsequently, that authorities, they used to demolish the building. If
No, that is, there are provisions to that
Lordship,
effect in the
Lordship.
2003 Act. But Mr. Bishwas, whether 14(1) is a cognizable offense?
The Act says so. It is a cognizable offense.
Act
Under-
says so.
Yes,
Which
15,
provision?
section 15.
Okay.
The Code of Criminal Procedure shall apply to an offense under section 14 as if it were a cognizable offense. It says about the procedure.
Okay. Then what is your submission, Mr. Chandran?
Lordship, this is for the purpose of investigation of such offense, Lordship, the subclause 1, Lordship, and 2. For the purpose of the matter other than 1, matters referred to in section 42 of the Code, Lordship, arrest of the person except on the complaint of an or.
Where are you reading?
Lordship, it's section 15, Lordship, 2003 Act.
Yes.
Or upon information received from the gazetted officer as may be appointed by the state government. Here the gazetted officer is the Lordship, District Commissioner, DLRSO Lordship. And the 16, if the estate officer has reason to believe that any persons are in unauthorized occupation of any public premises, the estate officer or any other officer authorized by him in this behalf may require those persons or any other persons to furnish information relating to the names and other particulars of the persons in occupation of the public premises, and every person so required shall be bound to furnish the information in his possession. Lordship, this.
Yes. Is there any bar in filing of FIR?
Lordship, as such, I haven't come across any bar, Lordship.
No.
But in this matter, why
You are appearing for the state.
Lordship,
What is your stand?
Lordship, for whatever I have studied, Lordship, there is no bar as such I found, Lordship.
Okay. So what is your submission?
Lordship, here this matter has a very checkered history, Lordship. It transferred from the Itanagar because of this petitioner being a public prosecutor. And at the time of appearance, the colleagues' allegation of the respondent number 2 here is that they might have helped him. So this matter went to Supreme Court, then it was remanded back, Lordship.
No, that is past.
Lordship.
But now what is your submission?
Lordship, as per my understanding, Lordship, this FIR can be done, Lordship.
Okay. Yes, Ms. Chaudhary. First informant.
First submission is that petitioner is a rank trespasser on government land. And he is guilty of grossly suppressing certain material facts and documents from this honorable court. Yes, whatever he has placed in fact, Lordship, is a one-sided fact, Lordship. And such conduct itself disentitles him from grant of any relief from this honorable court.
Why you are saying so? Yes.
Lordship, he has made a submission in this petition that an appeal has been filed and that appeal was pending. Secondly, also he has made the submission regarding personal vengeance.
I have not said appeal is pending. I have said we tried to file the appeal, but because the appellate authority is the informant himself, the appeal was not accepted. DLRSO under the Act is the appellate authority.
Where is that statement?
My lord, ground number C of my petition, page 10.
Lordship will check the synopsis itself, against which the appeal is pending before the appellate authority under section 12.
No, in the body of the petition, has he made any such statement? In the synopsis you have,
My lord, yes, paragraph 1, page 5. Well, in the middle paragraph, notice dated 8/10/15 and 18/6/19 against which the appeal is pending before the appellate authority under section 12 of the statute, who is also the complainant of the aforesaid FIR as DLRSO come. It was not at all registered. Though the word is used pending, but it was lying there. Since the appellate authority himself is the informant in the case. And DLRSO has lodged the FIR in his official capacity.
yes, anything.
And Lordship, this Arunachal Pradesh Act of 2003 is a special act and it has to be distinguished from a general act. Offense under section 14(1) is made out immediately when a person unlawfully occupies a public premises. Lordship shall come to the Arunachal Pradesh Act, which I have also annexed in my affidavit in opposition. Page 56, Lordship, it starts.
Yes.
The term deputy commissioner is defined in 2(1), 2(2), estate officer. Then 2(4), public premises means any land or structure belonging to the state government. Then Lordship will come to 2(7), unauthorized occupation at page 57. Unauthorized occupation in relation to any public premises means the occupation by any person of the public premises without authority for such occupation and includes the continuance in occupation by any person of the public premises after the authority, whether by way of grant or any other mode or transfer under which he was allowed to occupy the premises, has expired or has been determined for any reason whatsoever. Then Lordship will come to section 4(1). If the estate officer is of the opinion that any person in unauthorized occupation on any public premises that he should be evicted, the estate officer shall issue in the manner hereinafter provided a notice in writing calling upon all persons concerned to show cause why an order of eviction should not be made. Then section 5(1) at page 58, Lordship, where the estate officer is satisfied that the premises are in unauthorized occupation, the estate officer may make an order of eviction for reasons to be recorded therein that the public premises shall be vacated on such date as may be specified by all persons who may be in occupation thereof or any part thereof. In fact, Lordship, and then Lordship will come to section 12(1) regarding then appeal shall lie for every order of the estate officer made in respect of the public premises
No,
under.
my understanding till what I have understood from your submissions, that 2003 Act
Special act.
is a special act and it provides for two kinds of consequences for an unauthorized occupation over government land. One is civil consequence, which would lead to eviction of the occupant as well as demolition of the unauthorized building. And another is the penal consequence for which a criminal proceeding may be drawn. Now, what you are pointing is in respect of civil consequence.
Then regarding that the Code of Criminal Procedure applies, it's there in section 15, Lordship.
Yes.
The Code of Criminal Procedure 1973 shall apply to an offense under section 14 as if it were a cognizable offense for the purpose of such investigation. Page 63. For the purpose of other matters than matters referred to in arrest of persons except on the complaint or upon information received from a gazetted officer as may be appointed by the state government in the case of offense in relation to public premises specified in subsection 5(4) of section 2 of the Act. The respondent number 2 is a gazetted officer. He being a
CRPC, so. Yes. The information regarding commission of an offense under 14(1) may be given by a gazetted officer which may be appointed by the state government as per section 4(2) of the Act. What is 4(2) of the Act? Section 2 within clause 4.
section 4 is about
2 clause Roman 4. Two 4 is public premises. Okay. A gazetted officer as may be appointed by state government may file a complaint or give an information. Yes, continue your submission.
lordship. Then the petitioner before your lordship, in fact, had the remedy to file an appeal and under section 12(1), which he has not done.
Appeal against?
In fact, lordship, altogether around 15 notices were issued to this petitioner, and he did not even bother to reply to those notices. He was served with 15 notices. By the additional deputy commissioner, come estate officer. And this particular respondent number 2 was not the first estate officer who had assumed duty, lordship. Prior to him, there were other officers also. And in fact, I had given the chart, lordship.
No, they are basically against the criminal proceedings,
Lordship.
not against the order of eviction. Appeal lies against order of eviction or order for demolition. His plea is that 188 is barred by 195 of the CRPC. And offense under section 14(1), he's saying that his submission is that FIR could not have been filed. What is your response to that?
Your Lordship, 14(1) relates to an unauthorized occupation. And in this case, the petitioner, who was admittedly a ranked trespasser on government land, was unauthorizedly occupying that land, Lordship. So if any person, 14(1), Lordship, if any person unlawfully occupies any public premises, he shall be punishable with simple imprisonment for a term which may extend to 6 months, or with a fine which may extend to 2,000 rupees or both.
Okay. Anything else you want to say?
Lordship, this is not a case which falls within the conditions as laid down in Bhajanlal, Lordship, for quashing an FIR. And I would like to rely on Japani Sahu, Lordship, 2007, 7 SCC 495, para 14.
Japanese house citation is
2007, 7 SCC 394, para 14, Lordship.
what it says.
The general rule of criminal justice is that crime never dies. The principle is reflected in the well-known maxim, nullam tempus and locus occurrit regi. Lapse of time is no bar to crown in proceeding against offenders. Then it is a settled law that criminal offense is considered as a wrong against the state and society, even though it has been committed against an individual. Normally, para 14, Lordship, at page 401.
Okay.
Even though it has been committed against an individual, normally in serious offenses, prosecution is launched by the state, and the court of law has no power to throw away prosecution solely on the ground of delay. So Lordship, R.P. Kapoor, para 10. That there is nothing in section 154 which says that an information of a cognizable offense can only be made to an officer in charge of the police state. Just also relying on para 102 and 103 of Bhajanlal, Lordship. Power of quashing should be exercised very sparingly with circumspection, and that too in the rarest of rare cases. The court will not be justified in embarking upon an inquiry as to the reliability or genuineness or otherwise of the allegations made in the FIR or the complaint, and that extraordinary or inherent power does not confer any arbitrary power to act according to its intentions. The 7 conditions laid down in para 102 of Bhajanlal is not made out in this case. My respectful submission, this particular petitioner, having indulged in suppressing material facts, is not entitled to any relief, and if he has a relief, that was in terms of the act by filing an appeal and taking recourse to the remedy available there. In fact, no steps had been taken by this particular respondent number 2 under section 5, 7, 8 or 10. And section 12 appeal lies only
Against these order passed under these provisions only, 5, 7, 8 and 10.
10 and.
So no eviction order has been passed.
It's not
Passed.
You
only
have-
notices were issued altogether.
No, this is the notice.
15 notices were
Page
issued.
6, 2019 notice. This is the notice. Whereas I so and so hereby direct you once again to remove the building materials from the government land within 7
No,
days.
we are not concerned with that in this case. In this case, we are concerned with pendency of criminal proceeding, whether the FIR
Could have been lodged.
could have been lost or whether it is liable to be quashed.
188, your lordship, I did not submit more.
No, 188,
And 14.1, it relates to estate officer has the power for investigation under the Code of Civil Procedure when he is investigating an matter relating to, my lord, eviction and the encroachment. When it comes to the criminal part, he will assume the jurisdiction under the Code of Civil Criminal Procedure.
where,
That was-
from where you are
my lord,
saying.
it's in the 14.1 itself saying, for the purpose of investigation, that the investigation we find in the normal cases 144, 145, the executive magistrate investigates the matter of which, my lord, the Code of Criminal Procedure.
You read 15 clause 2.
Well, 15 clause 2 is says apart from, except on a complaint
And
and
or
information.
what does
Well,
this
it doesn't
information?
mean the information, my lord, first information report under section 150.
So that is your submission that
Well, if I may read again, for the purpose of matter other than one means section 42(1), section 42 of the Code of Criminal Procedure 1
yes, yes.
and 2. Arrest of a person, well, at this line, then except on the complaint or upon information received from a gazetted officer, as may be appointed by the state government, except on the complaint or, it doesn't say and, or information from a gazetted officer. One information has to be given, the proceeding has to be started. But this cannot be construed to be an information under section 154. The proceeding is completely different. It doesn't say the complaint or the first information report before the police officer. It doesn't say that 154 will be applicable in the case. It says for the purpose of investigation of such offense, as we find under section 144, 145, 147 of the Code of Criminal Procedure. Your lordship is aware, executive court has the power.
No, what it means for the purpose of investigation.
If I may read.
When investigation starts,
My lord, for the yes, executive magistrate may investigate, summoning the witness, summoning the person who has lost the complaint, attachment procedure, 107, my lord.
no, it speaks about investigation of offense.
Investigation of the offense committed by a person with regard to, my lord, encroachment of a government land without any authority. The executive magistrate, this estate officer, is empowered within the provisions of Code of Criminal Procedure for summoning the witness. Well, how the executive magistrate will summon the witnesses and the person and the complainant and the informant and the accused. There has to be some procedure. As in the previous section, foregoing section, Lord, if I may take your lordship, section 11. An estate officer shall, for the purpose of holding an inquiry under this act, have the same power as are vested in
That does not relates to
I
offense.
am just distinguishing these two facts, my lord. The estate officer has the power under the civil jurisdiction as well as under the criminal jurisdiction.
Where is that criminal
Well,
jurisdiction?
My lord, is 11, if I may interpret the act, because the act doesn't show ipso facto that the FIR has to be registered before the police officer against the wrongdoer. Whereas the act is very clear about the provisions, about the steps to be taken. But before that, before lodging the FIR, there is a provision for appeal. My learned friend is correct, but where to file the appeal? Before the same person who has lost the FIR.
Why are you saying that before lodging of
DLRSO,
the,
DLRSO is the appellate authority.
no, from where you are saying that before lodging of the FIR, appeal has to be filed?
No, my lord, the procedure prescribed under the act has to be complied with. Some notices are issued against the wrongdoer, rightly or wrongly. I have the right to challenge the order, eviction order, notices against the, before the competent authority. Here, the competent authority under the act is DLRSO. Thereafter, if the appeal is rejected and still I am holding the land without any authority, then the action under the Code of Criminal Procedure comes.
Okay.
But before fulfilling the requirement of section 12, coming directly to the criminal procedure by the estate officer, if it is, then it's okay. Under the Code of Criminal Procedure, he has given the power. But where is the power given to the DLRSO to lodge the FIR before the police officer? There is no power under the act given. Well, if it is not explicitly written in the provision, we cannot, my lord, read into the provision. Well, this cannot be read into the provisions of the act.
And also, Lordship, regarding the statement made that it was an action based on personal vengeance, Lordship shall check my affidavit at para 3.23 at page 30. I have elaborated that in the case arising out of Tawang PS case number 13/2019 registered against Niwang Genden, at the time of consideration of charge on 17/2/20, Niwang Genden pleaded guilty before the Court of Learned Judicial Magistrate Tawang. It's not correct, in fact, Lordship, that no steps were taken against any other person, but similarly situated Niwang Genden had in fact pleaded guilty. The Learned Court had imposed a fine of ₹200 for the offense under section 188 and a further fine of ₹500 under section.
I don't know whether FIR was lost under section 188, whether that provision was challenged. Well, this may not help in this case, because 188 very clear. Under section 195 CRPC, the procedure has to be followed for lodging an FIR under section 188.
Okay, anything else? Any of you?
And 15.1 says, once again, my lord, I am repeating at the, my lord, for my understanding. 15.1 is for the purpose of investigation and for the purpose of matters other than 42(1) and 2, that is the arrest when the person doesn't disclose his name before the magistrate. They have the power to arrest within his local jurisdiction. Other than that, arrest of a person except on the complaint or of upon information received from, it doesn't speak about anything regarding the offense under section 14.1. The 14.1 here, the Code of Criminal Procedure is applicable for the purpose of investigation, for summoning the witness, for summoning the informant, for summoning the complainant. There some procedure has to be prescribed. Here the procedure of Code of Criminal Procedure is applicable. So far as civil proceeding is concerned, their Code of Criminal Civil Procedure is applicable. It doesn't mean that the matter has to be instituted before a competent civil court. Well, am I clear, my lord? For the purpose of investigation for a civil offense, for encroachment.
What do you mean by civil offense? I am not understanding this phrase.
Civil offense is a 107. It's not an offense under the Indian.
There cannot be a civil offense. Offense is an act or omission punishable by law. If it is punishable, it does not remain civil.
Well, here the two parts. The act is divided into two parts. One is civil, one is criminal. When there is an encroachment, and there is a, my lord,
then the consequences are civil consequences.
Civil consequences so far is up to appeal is concerned.
Yes.
Once the appeal is decided against me.
No, from where you are saying that civil portion, civil part has to exhaust before taking recourse to.
But it's a chronological, my lord, provisions mentioned in the act says so. If I am continuing with the occupation of the land unauthorizedly, even after the dismissal of the appeal, then it comes under the Code of Criminal Procedure.
The 14 does not say so. 14 says that if you are in unauthorized occupation of government land, the offense is committed.
Before that, my lord, 13.7, finality of the order, 13. save as otherwise expressly provided in this act, every order made by an estate officer or appellate officer under this act shall be final and shall not be called in question in any original suit, application or execution proceeding, and no injunction shall be granted by any court, other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act. Before that, 12 is the remedy which is available to the petitioner who is in rightly or wrongly in occupation of the land.
Okay,
Well,
your
it cannot run concurrently. One person cannot be
okay, that is your submission. That
cannot be punished under the criminal law. Then thereafter this civil proceeding, demolition. Once the demolition is done, the offense is no more an offense because rightly or because your lordship is aware in the eviction drive in Assam, the persons are being evicted from the land whoever in the illegal occupation. But against them, no criminal proceeding has been started. There is no criminal proceeding. The power is given to the government. If somebody is found in illegal occupation of a land, he has to be evicted by demolishing the building. Even their notice of 2019 speaks so that if you don't remove your building, we will demolish. No steps were taken by the authority themselves. They have the power. Then 14 says, if I am continuing, even after dismissal or appeal, etc.
Where in 14 says that if you are continuing?
If any person unlawfully occupies any public premises,
Mere occupation is enough.
he shall be punishable with simple imprisonment for a term which may extend to 6 months or with fine which may extend to 2,000 rupees. Then provided that a person, there is a question of allotment. If any person who has been evicted from any public premise under this act again occupies the premise without any authority. So this 14 is also divided into 2 parts. Where illegal occupation and the continuing in the occupation. And there is one more submission. If it is assumed to be a offense as we find under the Indian Penal Code, cognizable offense where the FIR has to be lodged by the person, there is also a bar 368 because your lordship is aware when the punishment is 6 months or 1 year, the limitation period is prescribed under section 368. The FIR was lost after so many years. There is also a bar. Even if we presume that this is an offense similar to the offense under the Indian Penal Code where the FIR has to be lost before the competent authority. But 368.
It is a continuing offense.
It is a continuing offense, but when in the year 2015, notice was issued for my eviction, thereafter during the 4 years before 2019, no action was taken against me. Then in the year 2019, one notice was issued against me saying that you demolish your building or we will demolish the building. And no steps were taken by the authority for demolishing the building even as of now. Even if it is presumed, presume that it is an offense, then the police authority doesn't have the power and the competent authority doesn't have the power to lodge an FIR because the act doesn't speak so. We cannot read into the act to find out the meaning that the FIR has to be lodged for an offense under the Act of 2003. As my learned friend has already suggested before this honorable court that this is a special act under the government of Arunachal Pradesh. And the entire procedures are prescribed.
Okay, no
power is given to the estate
repetition.
officer.
Heard Mr. S. Vishwas, learned counsel for the petitioner. Also heard Mr. N. Chandran, learned counsel for learned public prosecutor, appearing for respondent number 3 and 4, as well as Ms. B. Chaudhary, appearing for respondent number 2. Hearing concluded, judgment reserved.
Well, the limitation part, not 368, I'm sorry, 468.
468, yes.
I'm sorry, 468. It says the period of limitation shall be 6 months if the offense is punishable with fine, 1 year if the offense is punishable with imprisonment for a term not exceeding 1 year.
And lordship shall take note that investigation for the present petitioner is complete.
Yes, charge sheet has been filed.
has resulted in fact.
And that's why I'm challenging the charge sheet also. Because the petition was filed before, well before filing the charge sheet, so I have relied on the Supreme Court judgment that even after filing the charge sheet, the FIR and the charge sheet can be quashed. And this
Which judgment?
Well, the judgment just now I have given the bunch of judgments.
You have challenged the charge sheet.
Well, the charge sheet was filed during the pendency of the criminal
Yes.
petition.
The-
And that's why the High Court had said, even our High Court also, the Supreme Court also, even though there is no
Where?
Joseph Salvara's FIR can be quashed after filing of charge sheet, paragraph 6 to 19, 158 page
No,
number.
that is not the question. The
But there also charge sheet was not challenged. The FIR was challenged.
What is the citation? In your compilation, what is the serial?
2011 7
Serial number?
Serial number 12. Serial number 12 and 13 are the two judgments I have relied. Citation 2011 7 SCC, page 59. Page 59 out of 2019 11 SCC 706.
Okay.
Paragraph also I have mentioned.
A compilation to Pongo. Okay, done. Wait for the judgment. I have marked.
Well, I may be allowed to replace the judgment by this compilation. Here I have
Yes.
mentioned the paragraph number.
Change that compilation. A to D, A to line. Nalagi.
Much obliged.
May I please, your Lordship, regarding item number 37, I was not present when the matter was called for, Lordship, and the next date is fixed on 16 of this month. Can the matter may be on 18, Lordship? I will not be.
Item number 37, show the presence of U. Chaudhary, legal aid counsel for respondent number 2.
Respondent number 2.
And we are refixing it on 18. 18.
Obliged.
None appeared for the appellant on call. List this matter on a date to be fixed by registry.
Item 40.
May I please, your Lordship? Lordship, this is a revision.
Yeah, please.
Challenge.
Lordship, this matter may kindly adjourn.
Why?
Lordship, the engaged counsel is absent today and
They are looking for the respondent.
Okay, otherwise time is also not.
Otherwise, time will also not come.
Heard Mr. U. Chaudhary, learned counsel for the petitioner. Also heard Mr. What is her name?
Sheikh Abdullah on behalf of.
Sheikh Abdullah. Appearing on behalf of Mr. S. Nawaz, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for respondent number 2. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Obliged.
Finish.